Yeah, clear. Lord, I have to mention for listing up to read petition.
Oh.
So it was last listed on 28/6/2024. Since then, Lord, it is not being listed.
Okay. 16th.
I'm obliged.
I have filed an IA that may be listed on Friday along with writ petition. Where matter may be urgency that this exam held on January 1, 2025 and form for class date is 12/12/2024. 12/12/2024. MBBS from class, my lord.
Okay.
The matter may be listed in Friday.
Okay. Okay.
May I please, Your Lordship? Lordship, I beg to mention for listing of a WPC matter, pension matter in the next week, Lordship.
18th.
18th, Lordship, obliged.
Right, please, Lordship. I'm praying for listing on WPC, Lordship, pension matter. Praying for listing for admission, Your Lordship.
19th.
Obliged.
We have listing petition for non-payment of arrear and carriage salary on 18th or 19th.
19th.
Last.
In item 4, Millard, we were supposed to file an IA. The IA has been filed, but it's not been listed today. If your lordship please, Lord, may call it or fix the matter.
Okay, let it reach. Let us see what happens.
My lord. But we have filed it, but it has not been listed.
Okay. You file your IA?
Yes, sir.
Who applies for it? Okay, heard. KU Amit and account.
My lord, regarding respondent, item number 6, my lord, no I has been filed. So, my lord,
Item
item number 6 may be taken.
Item 6?
Yes, my lord.
Oh, he's mentioning item 4.
Same, my lord.
4 to 5.
5, my lord. Regarding 5, my lord, no I has been filed.
If the lordship allows us to file the new affidavit, press affidavit, then it will cover the 5 also.
No, that is a separate fact, separate read petition, my lord.
Okay, let it come up with the IA.
Well,
But Mr. KU Amit, let it counsel for the petition. Mr. H. Amar, Leonard's standing counsel. UGC submits that he has filed an IA. Stop registry to list this matter along with the IA. When?
3 days, my lord.
Oh,
16, my lord, or 17.
Friday, 13th.
30.
My lord. Obliged.
Yes, please.
May I please, Your Lordship? I like to mention for a listing of an WPC any date after vacation, Your Lordship.
After vacation.
21st, Your Lordship, January.
Please, Your Lordship. I'd like to mention an item for listing. It was last posted in 26/2024. 26/2024.
Okay.
My lord, before any day before vacation.
Okay, 17th.
Obliged.
Lordship, I'd like to mention petition number 1522
When do you want
for
to
withdraw the matter.
withdraw?
Yes.
Okay. 11th. Day after tomorrow?
Okay. Obliged.
Item 1 of daily list motion.
Matter relates to non-consideration of appointment on compassionate ground, Lordship. Lordship.
No, with the OM standing in force. Now the issue is whether we and the OM is under challenge. OM is under challenge in a number of petitions.
Otherwise, my lord, 2013, but are dating 2013.
What we can do, we can issue notice. In the meantime, let the other matters come up. That will be better.
Lord.
But Mr. Ella Majumdar, Leonard Fountain, the petitioner. Issue notice. Education. Mr. G. Bekul and Standing Council Elementary Education appeals for the respondents 1, 2, and 3. No.
He is 1, 2, 3, and 4.
Where's your amended course title? Your post title has been filed, isn't it?
Lordship, I have filed Lordship, amended postal in file.
Where's the amended course title? What is X? But this, oh, let's see. Yeah, people understand FS 1, 2, 3, and 4. Huh? And Mr. B. Saitel, and government advocate, FS for the response number 5. Notice on respondents are complete. However, extra copies. No? Respondents are allowed to file affidavit list after 4 weeks.
All right.
Two.
My pleasure,
Huh.
Lordship.
Tabildar, any
Yes,
instruction?
Lordship. Legal, like plot legal practice.
Have you cancelled, have you given a direction that the proposal made by the petitioner is not accepted?
That is not even.
That's what. You give him an opportunity to again submit another one.
Otherwise, Lordship, legal, according to rule 9 clause
Yeah,
5,
that's
Lordship,
what-
legal practitioner is barred, Lordship, but he's a government servant, Lordship.
According to
Yeah,
them, what you're
yes.
saying is he seems to be he's well acquainted with the legal matters.
Lordship,
But then he's not a legal assistant. I mean, not a legal practitioner.
but the interpretation the authority
Oh,
has made is
So what do you want to do?
Lordship. Notice to put এখন affidavit file করলে hearing interim order is there. Lordship has passed already.
Interim is there. There's no doubt about it.
Lordship may issue short notice, Lordship, otherwise. Will Lordship place this, give a opportunity to the petitioner also that we are not accepting that one order will be accepted.
He's served an order.
Yes, we'll
And you give him an opportunity of placing his proposal.
Lord. Yes. That may be reflected. Otherwise, Lordship may issue short notice also, Lordship, in this matter, so that we can place our reply also, Lordship.
It's up to you.
No, Lordship, we'll give the, Lordship. We'll serve him a copy, Lordship, regarding our stand.
Then you want to take some time.
Yes, sir.
Okay, heard, Mr.
N.K. Sharma, Lordship.
Learning Council for the petition. On request made by Air Tabildar and the Standing Council Higher Education Department. When do you want?
After 2 weeks,
Now 2
Or
weeks is
after-
going to
after petition, anything.
list the matter on 8 January. Huh?
Good. Okay.
Interim order passed ready to continue.
Not-
till the next.
Deeply obliged, Lordship.
29 of supplementary list motion.
May it please your lordship. My lord, lordship knows, following amendment of the constitution, 100 and article 10, 15(6)(b) was introduced, my lord. Read with article 16(6), where, my lord, apart from any other existing reservation, 10% was earmarked for, my lord, economically weaker section. Now, my lord, if your lordship would kindly come to page 25. It all started with the admission year 2021. Now, it's a communication by the then Indian Medical Council, my lord. Now it is National Medical Commission.
Now, please come to the first para. The secretary in charge of medical education and health department of the states are hereby requested to send their proposal under EWS scheme in consultation with the DMEs and concerned institution under section 10A of the Indian Medical Council Act for the academic year 2021. Efforts may also be made to put in place additional facilities for teaching, etc. So, my lord, the direction was given to the states that whatever is the seats required to accommodate this 10%, my lord, then, my lord, under section 10A of the Indian Medical Council Act, they are required to be notified. Similarly, at page 26, my lord, in continuation of 8.4, this 18.4 communication was issued on the similar line. Now, what is most important is at page 27, my lord. This is again a communication by Medical Council of India to all the states. This was on, my lord, 6th of June 2019. I'll have your lordship's kind attention to page 28. Now, this is the guideline which was laid down by IMC, my lord. For 10% increase in seats for EWS quota, the following are the guidelines to facilitate its implementation. The 3 is very important, my lord. In order to implement 10% EWS quota, EWS reservation quota, increase in seat has to be effectively 25%. So, though, my lord, quota is 10%, but it was worked out by the Indian Medical Council that effectively it has to be worked out to 25% of the current intake to ensure that existing number of general and other quota seats are not affected. Thus, a college with current intake of 100 seats would need to add 25 seats, additional seats. So, if existing intake is 100, then it has to be 125. Then, my lord, will kindly come to page number. No. Guideline to follow. Now, my lord, page 30. This communication of the then DME, my lord, created a lot of confusion. Now, this is 9th of 7/2020. Whereas a judgment and order oral dated 25/20 has been passed by the Honorable Guwahati High Court in WPC number so and so, which is regarding increase of total number of existing PG seats in Assam by 25% in order to implement the reservation norm of 10% for EWS quota without disturbing the total unreserved seat. Well, by order dated 25/2020, a direction was issued by this Honorable Court to the authority to consider. Now, in my humble understanding, my lord, subject to what your lordships may say and what other sides may say, perhaps, my lord, the DME misconstrued the whole thing. Please come to page 31, my lord. The 3rd and 4th subpara. Whereas in the current academic session of 2020, after All India second round of counseling of PG seats, which concluded on 30th June 2020, total All India quota of 330 seats has been filled up with 200 seats only, thus leaving the remaining 130 seats being reverted back to Assam as unreserved seat. Whereas now there exists an additional 136 number of seats reverted back from 50% All India quota, out of which 83 number of seats are categorized as unreserved as per the state reservation policy, and with addition of these 83 number of unreserved PG seats, the total number of seats in the unreserved category stands at 234, and accordingly it can be considered that implementation of reservation norm of 10% of the EWS quota will not disturb the total unreserved seat. My lord, in my humble understanding, my lord, this was totally uncalled for, my lord. Whether for non-fulfilling All India quota seats revert back to state or not, that is not the issue. Issue is, my lord, to fill up 10% quota. The Medical Council is saying, you send us a list, we'll approve. Instead of doing that, my lord, this was resorted to. As a result, in 2020, my lord, a writ petition was filed for the first time. That order, lordships will get at page 32. Because of this order, my lord, this writ petition has to be instituted. Because the requirement was not to adjust my lord, the all India quota seats, but to enhance. Please come to page 34. Accordingly, we are, as your lordships got it, well? Accordingly, we are inclined to consider the passing of an interim order without expressing any view on the merits of the legal issues raised. For the purpose, we take note of the provisions of para 58 at page 56 and 57 of affidavit in opposition of Medical Council of India, where number of seats subject-wise approved for an increase for the year 2021 has been provided. Now, Indian Medical Council filed their affidavit in that case, my lord, where at para 58, they came up with this figure. This is very important. Now, my lord will kindly see, for example, medicine, for 1920, total seat available was 39. Now, my lord, 37% is the reservation. It works out to 14.48. We can take it as 15. So, my lord, 39 minus 15 is the 24 seats for unreserved. Now, All India Medical Council opined, my lord, to implement 10%, 6 additional seats are required. Am I clear, my lord?
Correct.
Now, this is how this whole thing was worked out. I'm not referring to each subjects. Please skip over to the next page. Now, my lord will kindly see total seats needs to be increased is 48 for post-graduation in different subjects. Similarly, for diploma courses, my lord, at page 35 towards the end, diploma courses, and at page 36, 31, 3. So 48 plus 3 is equal to 51. So, my lord, 51 seats is required according to MCI for implementing 10% quota seats for the state of Assam. Now, kindly see, para 10 at page 36. Accordingly, the authorities in the Medical Education Department of Government of Assam may continue and complete the admission process to the postgraduate degree and diploma courses in medical sciences for the year 2021 in medical colleges of Assam by increasing the number of seats subject-wise as provided in column 5 of the table provided in para 58, page 56-57 of the affidavit in opposition of the Medical Council in WPC number 20. So, my lord, an interim order was passed by this honorable court that 51 seats you increase. You give admission, it will be regularized. So, this was the order passed for the, my lord, admission year 2021. Now, my lord, similarly, if your lordship now comes to page number 40, my lord. My lord, before that, I would like to draw your lordship's kind attention to page 38. This was again, by this time, my lord, National Medical Commission came into existence in place of, my lord, MCI. Now, this is a communication dated 2011-2020. The commission is in receipt of several queries regarding seats granted for implementing EWS quota. The clarification to the queries are as below. As per guidelines of the Ministry of Human Resource Development and Ministry of Health and Family Welfare, for implementation of 10% EWS quota, the medical colleges recommended by the state, UT, central government institutions were granted one-time increase in the MBBS seats during the year 2019-20, 2021. Now, this is very significant. This increase in seats granted to implement EWS quota does not require annual renewal. So, this 51 which has been given to Assam, that need not be renewed every time by the Medical Council. Now, how to work it out? Annual permission as is required for seats granted under 10A of the IMC Act. My lord, if any seats are given earmarked by the IMC under 10A, in those cases, renewal is required. But for seats to implement 10% EWS quota, it's not required. So it's very important, man. Now, please come to page 40. This is the order for the year 21-22. Now, operative portion is at page 44. Now, paragraph 3, my lord, on top last two lines. This is for the year 2021. That order was passed, it is said. Now, please come to para 6. NMC, which is the successor in interest of the Artswell Medical Council of India, has filed an affidavit stating inter alia that number of seats that would be required to be increased for implementing EWS quota for admission to postgraduate courses in medical colleges in Assam for the year 2021-22 be also done in the same manner as it was done for the admission to the postgraduate for the year 2021. So this honorable court said, my lord, as it was done in the last year, this one. Now, actually, what had happened, my lord? This is only posing trouble for the students, my lord. The government could have done of their own. Every time they are doing, I'll show, my lord. Now, please come to para 8. In view of the stated stand of the NMC, we dispose of the writ petition directing authorities in Health and Family Welfare Department to the government of Assam to the do needful to increase the seats in postgraduate courses in medical in Assam for the year 21-20 in the same manner as it was done for 2021. Same 51 million. Because NMC has already said there need not be annual renewal. Then, my lord, will kindly come to, please come to para 9 at page 46. Para 9, after arriving at that figure of 48 and 3, the authorities and Health and Family Welfare Department may act accordingly and increase the seats as indicated above. A requirement of increasing the seats to be done before next round of admission so that no inconvenience would be caused to the candidate. So it was supposed to be done before the next round of counseling. My lord, then my lord will kindly come to page 47. This is the order for the succeeding year, that is 2022-23. Now, my lord will kindly come to page 51. Para 5. In order dated 24/8/2020 in WPC number so and so for the first year, my lord, in paragraph 8 thereof, the increase in the number of seats for implementing EWS quota as provided by the Medical Council of India was extracted and made a part of the order. As the same had arisen again, that is for the year 22-23, this writ petition is instituted. Same thing is being repeated every year, my lord. Now 6. NMC, which is the successor in interest of the Artswell Medical Council of India, had filed an affidavit stating inter alia the number of seats that would be required to be increased for implementing EWS quota for the admission to the postgraduate courses in medical colleges for the year 21-22 be also done in the same manner as was done for the admission year so and so in Assam. Now, my lord, these are the figures, and eventually at page 54, para 8, the authorities in the Health and Family Welfare Department may act accordingly and increase the seats as indicated above. A requirement of increasing the seats to be done so that no inconvenience would be caused to the candidate. So, concern of the court was, my lord, that the students are not put to any inconvenience. Now, my lord will kindly come to page number 57. So, admission up to 22-23 is over. Now, in respect of the last year, what had happened, my lord will kindly come to page number, page 62. This is 62 and at page 69, my lord, is the relevant order. In fact, the state government supported, my lord. Page 69. This was for the year 23-24, my lord, last year. Mr. B. Gogoi Lanet, Standing Council Head Department submits that an increase is required to be made and department may be permitted to furnish necessary application through proper channel for increase of 51 number of seats for PG, degree and diploma. Learned councils are in agreement that counseling process is likely to start in mid-July and therefore directions are necessary to permit the state to take necessary steps in this regard. Then para 11, list this matter again on so-and-so, by which date the respondents will file their response positively. Meanwhile, the state is permitted to increase 51 number of seats as indicated above. So we'll be praying similar order this year. Now, my lord, now what had happened this year?
I think last time also I passed one order, isn't it, recently?
This issue for this present academic session has already been addressed by your lordship. Lordship, then subsequently,
Why,
the DN was directed.
why letting them always come to court?
Yes.
Lordship, what has happened is that the increase which the learned senior council is placing, my lord, that is quite correct, my lord. That in the year 2020-21, there was an increase, which I believe, my lord, if I may start from that, my lord.
No, that part is what happened after
Only thing issue is that, my lord, lordship had directed that NMC has submitted that 83 seat has been permitted in the year 2020-21. This year also, they might use the same seats. My lord, in that light, the letter which has been sent by the DNE, my lord.
Well, can I just please complete it, my lord? Yes. Now, my lord will kindly come to page number 57.
57.
So, and up to my lord 23-24, everything is over. Now, please come to page 57. Now, my lord, this is the result of the net PG of 2024, my lord. Yes. Now, if your lordship will come towards the bottom, category general EWS 50 percentile. Qualifying marks. If your lordship will kindly come to page 60, my lord. 60. I'm sorry, 59. Serial number 76, my lord. Jit Protim Sharma, has your lordship got in, my lord. Now, as against the requirement of 50 percentile, he got 97.36. Is petitioner number 2 before your lordships today. Then at page 60, my lord, serial number 133, Anusha Sharma, petitioner number 1, as against the requirement of 50 percentile, she secured, my lord, 95.15. Similarly, at page 61, serial number 182, Chandrayani Bharadwaj, petitioner number 3, she secured 93 percentile. Yes. Now, my lord will kindly come to page 74, where the mischief has been done. Not 74, I'm sorry, my lord. Seat matrix to code page 83, my lord. 84. For the current year, my lord. Current year too. Now, kindly see, my lord, whether it is an innocuous mistake or it is deliberate, we don't know, my lord, but I'll point out the mistake. Page 84, seat matrix of 50% postgraduate seat of medical colleges of Assam, Dr. Swenso for the session 2024. Now, my lord will kindly come to top serial MD General Medicine. They have shown 23, as was existing, my lord, before 1919-20. Because now it is 30, I have shown that arithmetic, my lord. 37, 30 total. 39 was the total post. 37 is the reserve, that is 15 gone. So balance is 24. And, my lord, 6 was to be enhanced, so it has to become 30. Now kindly see, it has been shown as 23. Kindly see total seats. How it can be 23? It has to be 30. Then only you can accommodate. It could be an innocuous mistake or it could be, we do not know, my lord. Maybe these seats are traded off. We do not know. So many things are happening, my lord. Now, my lord will kindly come to page number 70. For example, please come to page 70, my lord. Page 70. What they did in last year. Page 70. Kindly on top see general medicine. Has your lordship seen that, my lord? Kindly see total seats 25. It should have been 30. That's why we had to come to court. If they would have shown us 30, in matter ends. Now, my lord, why they are bound to do is the answer is at page 88. Please come to page 88. There was an order of the Supreme Court. That is why, my lord, this view had to be taken. Now, this is a communication of my lord 27 to 2020. Implementation of 10% EWS quota in PG courses in government medical colleges for the academic year 2021. Now, please come to para 2. As noted from the table below, state of Assam, Bihar, Chhattisgarh, Goa, etc., 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 had more increase in seats than the seats required to be enhanced for implementing 10% EWS quota. These states have been informed to implement the reservation roster, including EWS quota, as per state policy, after including the seats. This word after has a lot of significance. After including the seats enhanced during 2021. Am I clear, my lord? So when you work out your seat matrix, you must add the increase of the EWS quota. And why this word after has come, my lord? Because there is a Supreme Court order, which your lordships will get at page number 2. So they are not adding. That's why this confusion is created every time. My lord, please come to page 97. That's the part of the Supreme Court's order, para 4. Having considered the matter, we are of the view at this stage that though state may act under enabling provision contained in Article 16(6) of the Constitution as introduced by 103rd Constitutional Amendment, unless additional seats are sanctioned by Medical Council of India, existing seats cannot be subjected to the provisions of the aforesaid constitutional amendment by issuing appropriate notifications, as has been done in this case. So eventually matter went up the Supreme Court. Supreme Court said, in the garb of implementing 10% EWS seat, you cannot tinker with the existing seats. That is why the word after, my lord, after this. Now, in this scenario, where is the scope for this year to indicate that there are only 23 seats for medicine? It should have been 30. So that means, my lord, these 51 seats, they have not added. Again. So continuously they are doing, my lord, 2021, 21, 22, 22, 23, 23, 24, now 24, 25. Now that is why, my lord, we are before your lordships. Now one more thing, my lord, if your lordships would kindly come to 88 once again, my lord. Effectively for state of Assam, though the requirement is 51, but NMC has sanctioned 83 seats. Granted permission. Letter of permission. So, my lord, therefore, my lord, my humble submission is the counseling is taking place. The schedule for the counseling is at counseling page 83. Huh? Yes, if your lordship would kindly come to page 83, my lord. First round of counseling took place from 18 November to 27 November. That is over, my lord. Now, second round is supposed to commence from 12th.
Where is that?
Day after tomorrow at page number 83, my lord.
State Council.
Yes, serial number 3, my lord. Serial number 3. Second round of counseling, last but one column, state counseling, 12 December, 24 to 23rd December. So, my lord, I am praying for a similar order as has been passed in the last 4 years. And page 74, my lord, this is how it should be done, my lord. Last year, they have clearly shown, my lord. Kindly see, my lord. Degree seats, total 663, diploma seats 8, total LOP 671, High Court order 51, total seats 722. But this was the figure for the last year. So, my lord, therefore, my humble prayer is, as was passed in the earlier order, these are also similar orders may be passed. Otherwise, my lord, we will be highly prejudiced. Meanwhile, let them file their counter, the issue can be thrashed out. But I'll humbly pray, my lord, for once and all, every time, why should they come, my lord? That is basically, my lord, state authority will have to take their stand.
Lordship. Lordship, first of all,
No,
Lord,
I think your stand is clear. In the last occasion
yes,
also,
yes,
you have
Lord.
met your stand.
MCA
But
is
the-
very clear.
Obamania, what is going on in your department?
Furnished a proposal to the NMC.
That was done, when was it? When was the last order?
Lordship,
issued?
there's one small lordship, maybe a gap in communication between both the departments. I've just placed this, my lord. My lord, my lord, this flag mark is lordship's order for this academic session with regard to the same issue, my lord. My lord, paragraph 6, my lord, lordship has correctly or observed the stand of the NMC, my lord, that the communication dated 27/2/2020, lordship, by that communication, it was a one-time increase. That communication was a one-time increase. And after that, my lord, paragraph 10, my lord, so the DM is directed that if they send a proposal of increase of 83 seats to the NMC, then the same would be, my lord, addressed. Now, this 83, my lord, maybe their proposal should have been that these are those 83 seats which were sent in the year 2020. Because NMC is always under the impression that, my lord, the seats that were increased in the year 2020, what does one-time increase means? That 2020 and 21, if the figure is X, my lord, then NMC is granted permission for X plus 83. So the figure ought to have been in the year 21 as well as the subsequent years, the figure should have remained at X plus 83. Yes. That should not come into the picture every year. So that probably is the communication gap between the departments for whatsoever be the reason. For that issue, my lord, every year a round of litigation is taking place before this honorable court. And even though 83 is permissible by the NMC, my lord, because the DME is asking for 51 and 51 is within 83, so NMC is granting permission for those 51 seats. However, clarifying on each and every occasion that, my lord, that the permission of one-time increase once granted should not be sought for on every year. Because every year it is sought for, then the NMC is under the impression that the figure is X. We have granted permission for 83. It appears that now they are asking for X plus 83 plus 83.
Additional.
Which, my lord, is a different process and where our PG board does not come into the picture. Then the MARB comes in, my lord. There has to be a physical inspection which takes about more than a year, my lord. So, my lord, this communication on the first page, which my learned friend is also speaking about for the health department, my lord, this appears that this increase is sought for new 83 seats, my lord. If it is stated in the communication that the 83 seats are implementation of those 83 seats which were already granted by the NMC communication dated 27/2/2020, then, my lord, I believe the picture would be cleared, my lord. So maybe, my lord, that may be clearly directed in lordship's order given 2 days time. 12th it is starting, I believe it goes on up to 23rd of December, my lord. For 2 days, my lord, I'll get the instruction. 2
No,
days.
my lord, I'll just explain one thing, my lord. I think a copy has been given to me also. This 21 just now, 21, 11, 24. My lord, this is totally erroneous. Who is asking for new seats? That means you want to admit somebody else. That's why I said, my lord, it could be an innocuous mistake or we do not know. And this gentleman is DME from 2010. Normally, a government servant should not be kept in one office for more than 3 years. He has developed vested interest. Kindly see, my lord, what he is writing. With reference to the subject cited above, I am to forward herewith an order dated 19/11/24 passed by the Honorable Guwahati High Court in case of so and so directed to the undersigned to send proposal for increase of 83. Where has your lordship directed for increase of 83 seats, my lord? Is it not misleading? Kindly see, my lord, court says, as was passed in the year 2021, we are passing a similar order in respect of 51. He wants to give admission to somebody else, my lord, taking help of this order. That is what I have understood.
Para 3 of my order.
Yes. Correct. Now, my lord, pursuant to this order, how can this letter at first page be there, my lord? Students are suffering.
Totally unnecessary. Why just can't we have?
Yes, Lordship. Let it be fixed on Friday, Lordship. I'll get the.
No, the counseling is starting on 12th.
12.
Lordship, but it will end on Lordship.
My lord, let us have peace of mind, my lord. We are students. We are not wagers.
It will end on 23rd.
We are not doing any wagering contract.
So I am asking only for this matter to be listed on 13th. Well, that's the.
You get this thing corrected?
Yes,
Your letter of 2111?
Yes, Lordship. Subsequently, we have issued another letter, Lordship. I have.
Where is that
Same,
letter?
my lord, over there also it's
But
not
Lordship, I'll make the
spoken
corrections.
directly, my
Lordship,
lord.
I'll ask the.
Tell your director to
Yes.
make the record corrections.
Yes, Lordship. I'll do that. It will be done, Lordship.
And
Now,
not only
whether it
this
is
year,
an
my lord,
innocent mistake or it is, my lord, there is something else.
and not only, my lord, I'll pray, my lord, that not only for this year, that the one-time implementation may be implemented
Every year.
annually, my lord.
Yes, Lordship.
And the NMC had placed that letter I have already placed, my lord.
No, we'll do one thing.
Yes.
Let them come with the instruction in the affidavit, but in the final order, we'll pass an order that no more, we will not entertain.
Yes.
The director, higher education, the medical education.
These 83 is a one-time, my lord.
Ensure that this is.
Properly done. Yes, Lordship.
No, my lord, that's why I said, my lord, in the government service, there is a rule. If somebody exceeds 3 years, normally is transferred. The understanding is one develops vested interest. We do not know. And my lord, that's the rule. That's the administrative prudence. Now, this man is sitting for the last 7-8 years. And is your lordship's order so unintelligible that he has to write this letter? Enjoying the, my lord, mercy of the regime, that's why doing all these things. Otherwise, is it possible for a government servant? My lord, my humble submission is, my lord, let tomorrow let them place the instruction. Otherwise, my lord, we are getting late, my lord.
Okay, heard Mr. K.
Yes,
Chaudhary, and senior counsel, assisted by Mr. J. Patwari, and the counsel. Petitions, stop. The has been filed by the petitioners who are MBBS graduates from the state of Assam,
These are not simple.
and they have cleared the NET-PG 2024 examination, and they are awaiting counseling process for being admitted into the various courses, various medical courses,
PG courses, my lord,
various PG courses
under the medical colleges of Assam.
under the medical colleges of Assam in the state quota. Stop. The grievance of the petitioners is that the number of EWS quota, which is 10%, if implemented, then the corresponding 25% increase in the quota for unreserved category is required to be made. Stop. It is also the further case of the petitioner that the said arrangement has been made by the state since the year 2020.
2020-21.
2020-2021 on the basis of number of seats since the year 2020-2021. Stop. Learned senior counsel for the petitioners has also relied upon various orders passed by this court in earlier occasions. Where directions were passed for what was one last order?
Yes, my lord. Last order is at my lord, page number 69. Page 69.
Where directions were passed. No, these are interim order only.
Interim order,
That-
page 69, my lord.
Final order.
Final order is at page 57, my lord. 54. In respect of
Were directed. Where the authorities in the Health and Family Welfare Department were directed to increase the seats in the postgraduate courses in the medical colleges in Assam. In terms of in the manner that has been done.
in terms of order dated, my lord, 24/8/20 passed in WPC 3007 of 20.
In terms of the order
Page 51, my lord.
passed in
Last sentence of
WBC
para 3.
number pass in WBC number
3007 of 2020.
this no,
First order, my lord.
first order was
Page 32, my lord.
Yes.
no passed in WBC 882/2020 by order dated 22/2/2022. Correct?
Yes.
Stop. Mr.
DK Boyta.
DK Bhatia, Learned Standing Council NMC, submits that submits that this court had also passed an order on
1911, man.
19/11/2024 in WBC 48/2022/2024, permitting the authorities in the medical medical education Assam to send a proposal for increase of 83 seats on or before 22nd of November 2024. Stop. The NMC was also directed to consider the proposal and pass appropriate orders on or before 29th of November 2024. Stop. However, it is submitted that the Director of Medical Education Assam, in his communication dated 21/11/2024, however, that by the communication dated 21/11/2024, made by the Director of Medical Education Assam, the proposal appeared to be an increased in the from the original to be an increased from
In addition to that one-time increase.
in addition to the one-time increase
Made by the NMC, my lord.
made by the NMC in the
By-
year
By the communication dated 27/2/2020, my lord.
by the communication dated 27
To
to
2020.
2020.
Lordship, that notification number also may be incorporated for clarity, my lord. It's
Yes.
page number 88. of their petition, my lord.
Yes, yes, correct.
Yeah.
So that no further ambiguity comes, my lord. Page 88 of the petitioner's petition, my lord. On the left hand side.
By the communication number, MCI dash 23 within bracket 1
Yes,
within bracket EWS oblique 2014
19.
19, my lord.
19 dash
Dash.
MED oblique 195 914 dated 27 to 2020. Stop. Para Mr. D. Obamania, Leonard, Standing Council, Medical Education Department. Press for a short time to enable him to receive instructions as well as to rectify the defects made in the communication dated 21/11/2024 made by the Director of Medical Education Assam. As well as the communication dated 30/11. Why do you keep on making the, I think what Mr. Chowdhury is saying is correct. Stop. Prayers aloud. We'll take it up tomorrow.
Tomorrow, my lord.
Can it be day after tomorrow?
No, day after no, day after to 12 তারিখ। No, no. Let it be tomorrow, my lord.
Have it at 2 o'clock tomorrow.
Yes, 2 o'clock.
This is the matter on tomorrow's what? 11th at 2 p.m.
Deeply.
A copy of
Yes.
For both of us, my lord.
to communicate.
Okay. Registry is direct to furnish 2 copies of this order to Mr. D. Opamania, Leonard, Standing Council, Medical Education,
50 লাখ কে হলো
as well as Mr. D.K. Bhatia, Leonard, Standing Council, NMC within the course of the day. Huh?
3 of daily list admission.
Make this your lordship.
Agreement for the timing.
It's all the time.
Why? John Manna, what do you think?
I may be allowed to continue my submission, my lord. He will be here.
Where is he?
Yes, lordship.
Where is your senior?
Lordship is coming on it.
Okay, then let him argue.
He has some health issue.
He has some health issue.
Yes, lordship, but he will come only today. Today he will come.
See, this court is also having a health issue.
Yeah,
You
yes,
can
lordship,
make
but-
out from my face.
but he will-
Still, I'm sitting here.
But he will come today only. He will do okay. For timing only.
Okay, let's wait for some time. Let's see.
Much okay.
Lordship, can it be at 2 p.m. then, lordship?
Let's see.
Lordship,
I don't want to fix that.
lordship.
6 to 10.
Yes, Tiranpi.
Lordship, we have filed our affidavit, your lordship.
When did you file it?
Filed it on 9. I didn't remember the date, your lord.
9th.
Yes, your lordship.
You've got a copy?
My lord.
You want to file reply or you don't want to?
No, my lord, this affidavit is neither here nor there. I have filed a writ petition seeking provincialization under 2011 Act. Provincialization with effect from 1/1/13, my lord. In the affidavit, they are saying all this net, let all this requirement, lordship. I don't know whether there is any relevance.
Lordship, go to the paragraph number 8 of our affidavit, your lordship, page number 38, your lordship. Page number 37, the last para, your lordship. They were not qualified, your lordship, as per the rule. They were only HSLC pass, your lordship.
I think you'll need to file a reply.
My lord.
Paragraph 8. The matching.
Now, my lord, my writ petition, this is the second round of writ proceeding, my lord. Earlier, I filed a writ petition and writ petition was disclosed in the light of judgment of Dilip Darpane, where stated if provincial district scrutiny committee has, my lord, allowed, my lord, in that case, presumption of provincialization. And I am, my prayer in the writ petition was that I am similar situated, my lord. That writ petition was disposed of with the direction to consider as per Dilip Dar's judgment. Now they filed the impugn order by which they are saying that I am not similarly situated. There is no, I have no connection with 2017. In the affidavit, entire affidavit, they are saying that I am not qualified. That's true. Under 17, I am not qualified, my lord. My
Okay.
content.
You want to file reply or not? Or
No, no.
you want to proceed?
Lordship. Lordship. My lord, in the. Huh? Lordship, then let it be posted after vacation.
You want to file a reply?
My.
Okay.
Only a date may be fixed.
Mr. J. Laskar and the counsel for the petition. Press for 2 weeks' time to enable him to file reply to the affidavit filed by the respondent. Correct?
A date may be.
Next year it will be getting list after 2 weeks. It will come up.
Obliged.
11.
Yes.
The petitioner before Lordship is a assistant teacher. He's
In this matter, Honorable Court has made a queries whether the annexure page
Five.
29 annexure 5 is a cabinet approve or not that memorandum. So my lord, instruction is awaited, my lord, so some time is required, my lord. Here. I have already communicated, but instruction is not yet received, my lord. One cabinet memorandum is there, and whether it was approved by the cabinet or not, it was in the query.
What's taking you so long to take
Yes,
the
madam.
instruction?
After 3 days, my lord, I will take the inspection. Already I have communicated.
Okay. But Mr. P.V. Barwal and the counsel for the petitioner. Mr. U. Shamal and the standing counsel. Secretary Education Department. Press for 3 days time to enable him to receive instructions in terms of the order dated 22/11/2024. Stop. Prayers allowed. List down today's what time? 1, 2, 3. When do you want?
Next Monday.
Monday, just Friday, Monday, both people will be here.
Friday, no.
Friday, only the instruction to be required. The cabinet member already been
Approved on.
Okay, Friday.
On the date day, the record, earlier occasion, they directed to produce the record. If the records come, then we can argue the matter. The record.
You have the record.
Record is not called for, my lord.
Yes, call for. Last
Yes.
the last order is specifically state they want the record to be produced.
Understanding Council, Secretary Education shall also produce the records.
And then, my lord, next week, my lord, Monday or any day.
No.
17th.
7th.
12 and 13.
May I plead a loss? Lordship, in this case, there are two matters again. In 435523, I am the petitioner, my lord, in this matter. And in this case, Lordship, I've challenged the order of the director, wherein the director has said that my B.Ed degree is not valid, my lord. And after hearing this honorable court provide order dated 31st/8/2023, my lord. May I kindly peruse this order, my lord? 31st/8/2020. There's a flag mark, my lord.
Okay.
The relevant portion is, I will read my para 4, my lord. Merit, madam. Para 4, madam.
Yes.
This court has specifically said that to determine the validity of my BEd degree, the Guwahati University is the only competent authority, madam. The director doesn't have any authority to do so. And as such, this High Court has passed this order. Now, I'd like to take a lordship at para 9, madam. Having a valid BEd degree is one of the essential requirements of being a principal of the higher secondary school. And when the degree of the writ petitioner, Bharat Chandra Talukdar, is in a cloud, that is, it may either be a valid degree or it may not be a valid degree. We are of the view that the balance of convenience and the irreparable loss in the circumstance would require that Bharat Chandra Talukdar be not allowed to discharge as the duties of principal till there is a till, my lord, till the decision is taken by the Guwahati University, and in the meantime, the respondent may allow any other eligible person, my lord. During that interregnum period, my lord, the private respondent over there was allowed to take charge, my lord. Now she is retired, my lord. This order is very specific, my lord, that the Guwahati University is the only authority who can determine my validity, my lord. So what Guwahati University has done, Guwahati University has filed a detailed affidavit, therefore declaring my BEd degree to be valid, my lord. I'd like to take the lordship to that affidavit of the Guwahati University. Page 70, my lord. Page 70. Para 2, my lord. 70, my lord.
Okay.
Para 2, my lord.
Wow.
On the day of the hearing, that is, as stated, 1, Bharat Chandra Talukdar, 2, Principal SDP College of Teachers Education. SDP is the college from where I have taken the BEd degree, madam. She is Anupama Devi, that is the private respondent, appeared in person and submitted their respective statements. Annexure A and B, accepted by Anupama Devi by Anupama Devi as because it has been appraised in writing Annexure C to the committee that by her that she had already completed her part of submission before the Honorable High Court and that she had already submitted an application regarding this to the Honorable Vice Chancellor Guwahati University. Next page, madam. The NCT was represented by Gagan Gaur so-and-so through online mode so-and-so, and opinion expressed by the NCT was also seen in writing on the same day by the Guwahati University. Para 3. After perusal of all the statements on record, as well as documents, and at the commission of the hearing, the committee observed that, number 1, as per the NCT, the SDP College of Teachers Education was granted recognition by BEd College from academic year 2014-15 by file number so-and-so, so-and-so. Number 2, Bharat Chandra Talukdar was duly admitted in the college. Number 3, Bharat Chandra Talukdar has produced NOC allowed by the Inspector of School of Buxar District College, Musalpur, which was in consonance with the government office memorandum so-and-so. Number 4, as per record, Bharat Chandra Talukdar was allowed by the SDB College of Teachers Education TU to appear in the examination after submission of the examination form. Number 5, when a college allows a student to appear in the examination after following all the requirements included the attendance aspect, the authenticity and immaculity of the decision is accepted and maintained all along in normal circumstances. However, in this matter, the present principal of the college could not supply the attendance register for that particular academic session, stating that the old records were destroyed as per the decision of the governing body of the college. Number 6, Bharat Chandra Talukdar appeared in the examination in the particular session and he passed in the said examination for which the said BEd degree was awarded by the Guwahati University. Number 7, the NCT stated in this statement that the validity of the degree of the petitioner comes under the purview of the affiliating body of the institution, that is Guwahati University. The same may be as ascertained from Guwahati universities and only. Number 8, as such, from what has been observed above, it is found that Bharat Chandra Chalukdar is a bona fide candidate for awarding the B.Ed degree session 2014-15 by the Guwahati University. Number 9, as such, the committee is of the humble opinion that the B.Ed degree in question as awarded by the Bharat Chandra Chalukdar is valid. So, my lord, as on today, right now, my B.Ed degree is valid, my lord, as determined by the Guwahati University. After that, what the private respondent have done, they have filed a writ petition, that is writ petition number 639/24, challenging my validity of the B.Ed degree, challenging the order passed by the Guwahati University, my lord. So far as this writ petition is concerned, I have nothing to say because whatever decision taken by the Guwahati University, and it is the Guwahati University now who has to respond in this matter. But as of now, my lord, they never challenge this order. That is the order dated 31st/8/2023, my lord. This is the order which is in intact, my lord. And as per this order, my lord, the court is very specific that as per is stated in para 9, my lord, till the Guwahati University has taken any decision up to that. So as the Guwahati University has taken any decision, my lord, I am now at present, I am eligible to sit in the chair of as a regular principal. A date less will prejudice me, my lord, because the Guwahati University has already taken decision. So far as that writ petition goes, my lord, only notice was issued. No stay order is there. And that thing is there. Again, they have not challenged this order. There is no stay order in this, the compliance in this order. What I am asking before your lordship, the compliance of this Honorable High Court order, my lord. Honorable High Court order dated 31st/8/2023, my lord. As to this order today, I am eligible to sit in the seat, my lord. The seat is holding by someone else person, in charge person. I'm not concerned with that. And so far the private respondent is concerned, he is not concerned about it because he's retired. So he's not challenging for my seat now. He's a retired person.
In your writ petition?
Yes, in both the request, he's a retired person. He's already retired. So
you are retired?
I am retired. Already, Lordship, the decision by university has been challenged by me before my retirement. And thereafter, Lordship, another person has also challenged this decision of the Guwahati University, because this court, honorable court, has directed the manner of obtaining the B.Ed degree by Bharat Chandra Chalukdar. Because Lordship has already decided that remanded the matter to the BTC to take a fresh decision on the basis that he was a regular teacher of Boroma High Secondary Schools. And as per NCT regulation, 208 attendance is a must for attending B.Ed degree. They have produced an office memorandum that for a night shift, they can attend the B.Ed degree for night shift. But Bharat Chandra Chalukdar was attending a regular classes in daytime in B.Ed degree in SDP College of Teachers Education. That is why Lordship has decided and remanded the matter to the BTC authorities. And BTC authority has already removed him from church, reverted back him from service, and held that his B.Ed degree, the record produced by them, is that he has not obtained any consent from the inspector of schools, not from the director of education. So he has been removed by the BTC authority. That order has been challenged by him by filing a writ appeal. Writ appeal has been withdrawn. Lordship order has been challenged before the division bench. Remanded it back to the state government. It was challenged before the writ appeal. Writ appeal has been withdrawn without any liberty. Now Lordship order has remained in field. Lordship has already decided that to take decision by the BTC authority for removing him. And BTC authority rightly, after taking the decision, rightly decided that his B.Ed degree is not valid because he has not obtained any consent from Lordship. Will kindly see the BTC authorities. Lordship order first. One moment, my lord. Whatever the private is submitting is submitting retrospectively. Today, as on date, this order is valid, my lord. It is true that your lordship was passed an order, and while passing an order, your lordship passed an order. They were directing the director to verify. Without verifying, my lord, properly, my lord, what he has done, he has exceeded his power, my lord, and he has said he has cancelled my B.Ed degree. Therefore, this order today on date, my lord, this honorable court has said no. The director doesn't have the authority to do so. Only the Guwahati University
No,
can do so.
Goswami, the petitioner in 639 has retired. Retired, and second petitioner who was in charge of the Boroma High Secondary School have filed a separate petition challenging the Guwahati University. Where is that petition? That petition is WPC number 6381 of 2024. That is listed today? That is not listed.
So as on today, there's nothing embargo in there, madam.
Listed on 412. 639 has become infractions. No.
not infractuous, because we have retired from service. We are not claiming any promotion in the said petition. We have challenged the decision of the Guwahati University regarding decision. What this court has directed. Lordship will kindly say the Lordship order dated page 107 again. Page 107.
My lord, I don't know why a retired person is submitting, my lord.
Then I'll argue, Lordship.
Let me complete, my lord, first of all. Let me complete. My lord, so I'm on that, my lord, that as on today, this order is valid, my lord, the 31st/8/2023, my lord. And the private respondent has already retired. Now, after retiring, if a lordship passes any order, whatever order, the effect will be zero on the private respondent. If the validity of my sponsor is valid or invalid, nothing will happen to the petitioner, my lord. And this is a writ petition. First of all, to file a writ petition, there has to be violation of fundamental right. I can say.
No, 1 minute. That's a different thing. Yes, Guwahati University.
And BTC authority have to file affidavit in this case.
Yeah, Chaudhary.
The new case, like a present income, that's fine. Here, lordship, that affidavit we have sought for instruction. And lordship, that affidavit, I think, will cover everything.
That affidavit in that other petition will cover the whole.
Yes, because the basic issue is that all of them are challenging the report of the Guwahati University.
On what basis you are challenging?
No, both the petitioner respondent here in the first case and the petitioner and the other person.
Lordship, two things are there. For a moment, my lord. A person who is retired is challenging the validity of BA degree. Another person who is a in-charge principal, my lord, he's not in the same cadre. I'm a regular appointed principal. There is a difference between a regular appointed principal and an in-charge principal. It's just a makeshift arrangement. So he had challenged the validity of BA degree. What will he gain, my lord? There's nothing in it, my lord, because this is already over here, my lord, validity. A person has already challenged the BA degree. During the pendency of this case, 639, wherein the BA has already been challenged, other person done the same thing. Exactly the same thing, my lord. One person challenged, another person is challenged.
In that other petition, that Guwahati University's decision is challenged. In that other petition. In this present petition, now the petitioner has retired, isn't it?
Second petition will be retired.
Huh?
Petitioner in the WPC number
69.
69 has retired.
Huh?
69.
And the same decision of the Guwahati University is challenged in another petition by another petitioner.
Which is also challenged in 69 also. Which has already been challenged in 69.
No, 69. That's why whether 69 will survive now. Now that you have retired.
I have retired. I am not claiming promotion in 69. I am challenging the decision making process of the Guwahati University. Because I am also appeared in the selection process for the post of principal. I have not given the regular promotion to the post of principal. I will get the benefit of promotion and everything if that petition is allowed. Because I will get the consequential benefit. Consequential benefit of promotion I will get if that petition is allowed. Because
have you seen the latest Supreme Court order?
Lordship.
On that issue?
Lordship.
You check up on that. Anyway. Then Chaudhary, then we'll get this matter listed along with the writ petition.
Yes.
And then we can dispose of all together. Fukan? No, that's fine. That we have gone through. On the basis of the NCT's the NCT also was a party in that hearing. Correct? Petitioner was a party.
Right.
In all this, after doing the hearing, you came to the conclusion that the petitioner has rightly got the decree and that his decree is valid. Now that validity, the decision of the Guwahati University is challenged in the 639, though the petitioner has retired. And another petitioner has also challenged the same Guwahati University decision. So we'll hear all those matters together.
I have nothing in it, my lord, because first of all, since the validity of the BA degree has been put to challenge, my lord, and this, as High Court has categorically stated, that the Guwahati University is the only competent authority. So the affidavit of the Guwahati University is necessary, not the government. Because Guwahati University is the person. What in 69 they have challenged the validity of the B.Ed degree, which has been validated by the Guwahati University.
No, that's fine.
Yes.
That's why I'm saying.
My lord, since
Have you filed your affidavits in those writ petitions?
So, here,
Which one? 639.
4355.
Oh, 4355 that I've gone through. But how about the challenge of your decision? Six three nine is not the main issue. The other writ petition. That there you'll have to file your affidavit. Or it's up to you. 639 also you can file together.
I'll file it 639.
Okay. So when can you file? 10 days.
My lord, I've said humble prayer, my lord. Since everything is given by the, I'm a regular appointed principal, my lord. As per this order data, I may be allowed to continue as a principal.
No, that,
Because-
that part we'll take care of later on.
Because as per this order, my lord, I am entitled to sit.
Now that thing is also under any stay order is there in your writ
No, my
petition?
lord, no stay order. That is the thing.
Lordship has already BTC. Lordship had to set aside the BTC's order. Lordship has remanded the matter by order dated. Lordship will kindly see order dated page 95.
Page
26/6/2023.
Page?
Page 95.
Of the writ petition.
Lordship.
Page 85. Okay.
26/3/2023 is Lordship order. Lordship has directed page 99. Page 99, para 12.
Yes.
A perusal of the order that remand issued by the Director of Education BTC would clearly indicate the report of the Inspector of School BTC Mosalpur dated remand was not taken into account while passing the speaking order dated 18/9/2021. Therefore, fitness of this thing's resolution is disposed of by directing the Director of BTC to consider the matter afresh as to whether the private respondent has legitimately obtained B.Ed degree from SDB College of Teachers Education, who, after taking into consideration the report of Inspector of School BTC Mosalpur dated 23/7/2021, as well as the fact that SDB College of Teachers Education does not have evening shift of that B.Ed course, and also Office Memorandum dated Iman, thereafter Director of Education BTC shall pass a revision order in accordance with the law within a period of 1 month from the date of received this order. Consequently, the speaking order dated issued by the Director of Education is set aside. Thereafter, speaking order has been passed as page 101. Lordship had to set aside this order also. Ultimately, page 102. In view of the above, Lordship got it. In view of the second last paragraph, in view of the above, there is found irregularity in the B.Ed degree of Bharat Chandra Talura, subject teacher of Boroma High Secondary School, Boroma, who was appointed as a principal of school on 3/9/2022. Since his practice B.Ed degree training of SDB College of Teachers Education, TU, has he got appointment on benefit of doubt due to misrepresentation of gradation list submitted by the Inspector of School, Baska, wherein respondent was reflected to be B.Ed degree holder was miscommunicated of the facts for obtaining B.Ed degree. It has happened to be without due process as per rule provided by the Government of Assam, Office Memorandum dated Iman, which established that B.Ed degree is unofficial as per report of the Inspector of School, Baska, dated 23rd July 2021. Considering the fact of the case, speaking order dated related to the legitimacy of B.Ed degree of SDB College of Teachers Education, TU, in respect of Bharat Chandra Talura, an appointment order of principal issued from this end in respect of Bharat Chandra Principal, Boroma High Secondary Schools, Boroma, both hereby treated to be cancelled. Lordship have to set aside this order also. Cancel. The petitioner Anupama Devi, Vice Principal of Boroma High Secondary School, Boroma, is hereby temporarily allowed to hold the charge in charge principal of Boroma High Secondary School, Boroma, and Bharat Chandra Talura till regular principal is made. Bharat Chandra is reverted back to the original case. So Lordship have to set aside this order, and this order has been passed as per Lordship order, and that order has been challenged in writ appeal, and writ appeal has been withdrawn. Because this order have to be set aside by your Lordship, and that order has been passed by your Lordship. Without Lordship, besides this, Lordship kindly see why University has passed this order and manner of giving the order. Lordship kindly see page 101.
because Lordship have to regularize that as per NCT's affidavit that has not been produced by the university. NCT has filed a specific affidavit that 200 days attendance of a teacher for obtaining BEd degrees is compulsory and mandatory. A regular teacher, how he can attend 200 days teaching in BEd college in day shift?
Okay, okay, no, you file your affidavit.
I'll file it tonight. But that 638 of 2024, by the way,
That will be taken.
I just want to reply on this.
No, I'm not hearing the matter. 638.
81.
No, the pleadings are also complete.
No, that's notice has been issued. Notice has been issued.
They will file affidavit, they take together.
1 week back. Notice was issued 1 week back.
I don't know, my lord. I am not
Okay.
aware of the.
There's a private respondent there.
Lordship, he is here. He is a private respondent.
Then I think it'll be coming up in the order column.
Lordship.
But this is in the admission column.
Lordship may take this matter because process is same, decision making will be same.
But then have you got a copy of that?
No, my lord. I don't give the copy.
That is the issue.
We have taken the steps by registered post ready as directed by this court.
Okay.
We'll give you an extra copy.
Maybe
We'll give an extra copy.
you will be appearing in that matter.
My lord.
Most probably.
My lord.
Of course.
My lord.
You don't have
Absolutely.
to kapla
My lord. My lord.
Okay, heard, mister.
My lord, one humble prayer, my lord. My lord. Let them do whatever they want to do. It is a total now bunch of cases to be determined. The determination will be whether I have a valid BEd degree or did not.
That's why.
That is. But once the Guwahati University has already been determined, my lord.
That's fine.
And this order is already 2 days in due, my lord. So as per this order, I am entitled to sit on the chair of the
That's
other
fine.
reporter.
Just wait. Have some patience. Heard, mister.
As so.
Learned counsel for the petitioner in WC 4355 oblique 2022. Also heard Mr. S.K. Goswami, learned counsel for petition in WC 639 oblique 2024. Stop now. Mr. A. Fukan, learned standing counsel, Guwahati University. Praise for filing an praise for how much time?
10 days.
Praise for 10 days time to file affidavit in opposition in WC 639 oblique 2024. Stop. The prayers allowed. We'll give a fixed date, give a date after 10 days.
Eight January.
We have to go to January then.
Let the matter come up on 8 January, and in the meantime, he can file the affidavit.
This is the matter on 8 January, along with WBC number 6381 of 2024. Correct, 6381.
Obliged.
Item 14.
Yes.
Our affidavit, my lord.
Have you got instructions?
No, my lord.
Then
No.
They have been taking time to file the affidavit since 2023, 30th of November. 30th of November 2023, my lord. And the issue is very simple. My lord have gone through, my lord. It's promotion to the post of in-charge headmaster. My lord, you kindly come to page 55, my lord. There is an order of the director of the secondary education, my lord. My lord comes to page 56. 56, my lord. 55, the order starts, my lord. Page 56 is so 56, my lord, third paragraph. The seniority. Am I with your lordship? Seniority of Mobidur Rahman, he is a petitioner, my lord. In the Bamanbari High School cannot be denied, but due to pending of judicial proceeding against him before the Honorable CGM Nalbari, he may not be placed as in-charge headmaster of the school. However, on acquittal, Mobidur Rahman, BSc B.Ed, assistant teacher may be allowed to hold the charge of the headmaster of the school. And he is,
I know.
yes,
In this case, I have filed an impediment petition, my lord. I am the in-charge headmaster of the school, my lord. It is filed on 7, my lord. It may
You
be.
filed in IA?
Yes, my lord. My lord, it is not listed, my lord.
Oh.
My lord, sir, kindly taken on Friday, my lord, along with the IA, my lord.
Can you get your instructions by done? It's basically your own order.
Yes.
You said that after the petitioner is acquitted, then he can hold the post.
I have annexed the seniority list also.
So basically is that what we are going to do is remand it back to the director,
Director, yes.
saying that so and so has happened, now you take a call.
Yes,
That's all.
yes.
But then you file your implementment
Yes,
application.
my lord. On 7th, my lord, I have filed.
Okay, heard Mr.
I'm
P.K.
PK.
Munir and the counsel for the petitioner. Mr.
K. Kolita.
K. Kalita, Learned Counsel, submits that he has filed an IA on
On 7, my lord,
7th of December.
filing number
2024.
1494.
Registry is directed to list this writ petition along with the said IA on
Friday, my lord.
Friday,
Yes. Friday.
13th.
Friday the 13th.
Item 15 to 18.
With the lordship. This is the lordship that mutual transfer matter, lordship may remember. On last occasion, they were directed to file an additional affidavit. But lordship, after going through the affidavit in opposition filed by them in WPC 2724, they have already taken that stand in the affidavit, lordship. So may I pray to dispose of the matter, lordship, as because in the meantime,
Yes,
My lord, this matter has been handling by my friend Fukon, my lord. He has some personal difficulties, my lord. He is not available. So my lord, may fix short date, my lord.
Lordship, I'm saying what lordship on
And
the
previous
basis
with
of
him,
your lordship's direction, if your lordship direct that as in the meantime already on last occasion, your lordship has also pointed out that private respondent already joined in the post and she has not committed any contempt of court as because before the stay order she joined, lordship. So may I pray if your lordship direct and I am also ready to join in my post where I was transferred, lordship. So with the direction of this court, as because lordship, it is not willingly, the petitioner is not joining that post. It is not a case that she is not willingly joining that post. There is a stay matter by this court. So if your lordship dispose of in that aspect, that I will join my post.
to the new post.
Lordship, in the new post, in the post where I was transferred, lord. As because they have already taken a stand that the respondent has joined in the school of the petitioner, as such the petitioner of this case is without any post, which makes her ineligible for a salary. And already departmental proceeding was also initiated. So lordship may after some time he is waiting. Lord.
Okay.
After some
Meantime,
time,
we
your
can think
lordship
about
can,
it.
yes, lordship,
We
also
can
you can
dispose
dispose
of
it
on
of.
that line.
Lordship,
Directing the petitioner go to his new without
Lordship.
disturbing Majumdar's.
Lordship, on 16/3/2023, both of them applied. Teacher 1 is private respondent and teacher 2 is the present petitioner, Suparna Roy. And there
Where's the date?
date is not mentioned here, lordship. Online portal, but it is
16/3.
16/3/2023. I have taken it from it. And thereafter, page 15, annexure 2, lordship. We, lordship, written a representation to the Director of Elementary Education, prayer of cancellation of my request for mutual transfer on ground of my deteriorating health condition. I have the honor to inform you that I am Mrs. Suparna Roy, who is working as assistant teacher 1239 number Vivekananda Harijan LP School, Karimganj, since 8 February 2021. Recently, I applied for online mutual transfer against the post of Mrs. Moshumi Das, posted at 828 number Radhanagar LP School, Kachar district. But sir, few days back, I was diagnosed with acute urinary tract infection along with chronic kidney diseases, for which the treating doctor has advised me to restrict my travel and body movements for which it will be impossible for me to join the aforesaid place of posting if I am granted the transfer application. Hence, sir, I request your kind soul to be gracious enough to reconsider my application in view of my deteriorating health conditions and cancel the said application done on behalf of me. That letter is dated 8 May 2023. And there are some, Lordship, the doctor's report, those were,
Ultimately, this order came 19 October.
yes, Lordship. Page 21, Annexure 7, Lordship. Basically, I was challenging the
You are
mutual
teacher two, no?
clause number 2, Lordship.
You are Suparna Roy. Teacher
Suparna
number
Roy.
2.
Yes, Suparna Roy. I have filed this writ petition challenging the clause number 2, Lordship. There is a specific clause that in case an applicant pairing in mutual transfer is not in the school anymore due to resignation, demise, or not.
Anyway, now we are going to go to this,
Lordship.
so I'm not going into all this.
Lordship. Factual part, your Lordship. This is the factual part, Lordship. Thereafter, again, an order was directed, passed against the petitioner that you go and join in that post, Lordship. After that, I have filed this 6595 petition. And while issuing notice, this mutual transfer order was stayed by the Honorable High Court, Lordship.
Okay.
And before this stay order, the private respondent came and joined in that place, Lordship, in my place. Thereafter, during pendency of this writ petition, I have filed one IA, Lordship, for release of my salary, IA 499, Lordship. There is a prayer to release my salary and to allow the petitioner to join in her post, Lordship, in the present post, not the transferred post, Lordship. That IA is also pending. And thereafter, another speaking order was passed by the private director, Lordship, saying that that clause was removed. That is not retrospective, but from now onwards, that clause was removed. And thereafter, Lordship, another direction was passed by the director that you go and join. So I have filed one contempt petition challenging that part and one writ petition challenging that speaking order. In all the cases, notice was issued. And thereafter, Lordship, a show cause notice was served upon the petitioner challenging that I have filed WPC 2724. While issuing notice, that Lordship, show cause notice was also stayed by this court. So
What
they have
about
filed-
the show cause?
There is a stay from this court, Lordship.
No, that's the, but then once the stay is removed, then
That part previous with my.
this is the problem, no?
Lordship will pass that, and there was no stay order was vacant. That show cause was not removed, Lordship. It's still pending. It was under stay from this court. Your Lordship may set aside that order as because that is the afterthought of the present petition, Lordship. That was the action taken by the government officials, Lordship, only after issuance of notice by this court, Lordship.
But that show cause was issued because you are defying the government's transfer order.
Lordship.
Now, whether that after you go and get yourself
Lordship
go
can
and join
dispose, Lordship can dispose it up, setting aside that show cause notice. Lordship.
No, how can I set aside?
As
There
because
has to be a reason.
Lordship, that
But
I
then
have
the issue is who's the one? Katania.
F.
A. Fukan.
Yes.
Where's A. Fukan?
that was issued only because I have not moved to my transport post, Lordship.
That's why.
Lordship. So now I am, as per our court's order, if stay has been removed by this court and I may be allowed to join the post, Lordship, as per court's order, then that show cause will go, Lordship.
You don't have instructions. Because there are two, the show cause is a different issue.
Lordship.
You defied the order of the government.
No, Lordship, that was only after stay of this court, Lordship.
That's why you defied the order of this government.
Lordship.
Not proceeding, then you came to court and then this court gave you a stay order.
Lordship.
That the show cause was issued. Then I think I'll let Fukan come.
Show cause was-
When is Fukan coming?
Lordship may
Day after tomorrow.
at 2 p.m. Lordship.
Day after tomorrow.
No. Is Fukan present in the court premise?
No.
Yeah.
They have appeared all the time. Contempt also he is the youngest constable.
Anyone-
Contempt also he is the youngest constable.
Anyone can appear, Lordship, there. Lordship,
No, this first case can be disposed. There's not an issue.
Lordship.
But
At
the
least,
other cases,
Lordship, at least your Lordship, this
the
petition,
small
this
one, they
petition
have to
can be
remove by-
disposed of, Lordship.
okay. 6595, huh? Then contempt also we can dispose it of.
Contempt and the other writ petitions will remain, Lordship.
No, contempt is what?
Contempt is, Lordship, directing that second time, in spite of the stay order, the respondent again directed me to join my service.
So that's fine.
Lordship.
Since we're disposing, we can close the contempt.
Lordship. And
And,
all the cases your Lordship can dispose as.
no, otherwise, except this, what is 1492,
1492, the second speaking order I have challenged, Lordship.
second speaking order?
Yes, Lordship.
What speaking order?
Out of that speaking order, contempt and 1492, Lordship, arises.
Then 1492 also can be disposed of,
Lordship.
except 2724.
Yes, Lordship.
That will keep it pending. Let Fukan come.
Lordship.
We'll take over. WBC 6595 public 2023. Huh? And just give me the file. This one will be 1492. And WBC 1492 of 2024. This will be a common order. Stop. Oh, okay. Heard MS R. Chowdhury, learner counsel for the petitioner in both the writ petitions, as well as Mr. G. Beku, learned standing counsel, elementary education department for. Okay, it's just a elementary education department. And Mr. F.U. Barguya, learner counsel for the respond number 7.
In WBC 6595.
In the other one, you also party?
Yes, 1492, I am also the party. Respond number 7.
Both as respond 7.
Yes.
For the respond number 7 in both the writ petitions. Huh? Stop. Para. WC 6595 oblique 2023. Huh? Then you make a line. The petitioner in the present petition, while serving as you're serving as assistant teacher.
Yes, sir.
In 1239 number Bibi Kananda Harizan LP School, Karimganj. Applied for mutual transfer along with the respond number 7 for transfer to 828 Ratanagar LPS on 16/3/2023. Stop.
Radhanagar LP School, Kachar district. Lordship.
Kachar district.
District transfer.
District Kachar. Stop. Para. No, continue. In the meantime, the petitioner developed some ailments, and accordingly, as she could not travel, she made an application, made a representation on 8th of May 2023 before the Director of Elementary Education Assam, praying for cancellation of her request for mutual transfer. Stop.
Again, another order was passed, Lordship, page 23, Annexure 9, 1st of November 2023. Both the orders under state.
That's a different thing. However, by an order dated 19th October 2023, the Director of Elementary Education, Assam, transferred the petitioner to 828 Radhanagar LPS, Kachar district, and the respondent number 7 to 139 number Bibikananda, Harizan LPS, Karimganj, on the basis of their request for mutual transfer. Stop. The Director of Elementary Education, Assam, also passed an order on 1st of November 2023 directing all the block elementary education officers, Deputy Inspector of Schools, District Elementary Education Officers to release all teachers who have been transferred on mutual and who has been transferred by mutual transfer and single transfer, and to ensure that the orders are obliged during the time mentioned in the transfer orders. Sapara. The petitioner, being aggrieved with her order with the order dated 19th October 2023, by which she was transferred to 828 Radhanagar LPS, Kachar district, has filed the present writ petition. Stop. Para. Not para, in the next one, you said WBC 1492 of 2024. Stop. Here the order is what?
In 6595 or
Yeah.
or 14.
No, 1492.
1492, Lordship. That is the speaking order, page 20, Lordship, Annexure 6. Only the conclusion part.
Okay. On top, what? This court, continue on top. While issuing notice on 17/11/2023, state the order dated 19/10/2023, as well as state the orders dated 19/10/2023 and 1/11/2023. Stop. Then I'll say WBC 1492 of
While issuing notice, Lordship, there is a direction passed by the court that in the interim order is suspended. It is further made clear that filing of the present writ petition shall not be a bar for the respondents to dispose of the representations
the order
stated.
with a further direction that the pendency of the writ petition shall not be a bar for the respondents to dispose of the representations dated 8/5/2023 and 26/10/2023 made by the petitioner. Then WBC 1492 of 2024, underline it. During the pendency of WBC 6595 of 2023, comma, the director of elementary education Assam
Page 20 and 21 of that
was a speaking order
disposing my representation.
dated 21 to 2024, disposing of the representations dated 'Where's the transfer order? Where is it? Has she mentioned the representation?
Representation, Lordship, it is mentioned in the order dated 17/11/2023 that the representations dated 8/5.
No. In the director's order?
In the director's order, Lordship, that was not mentioned.
Okay. Disposing of the representations made by the petitioner, by which
Only it was mentioned.
in the relevant portion, which is under page 20, A to A. Stop. Being further aggrieved, the present petition has been filed by the petitioner. Stop. Para. During the pendency of the aforesaid two writ petitions, comma, the respondent number, the
7.
how about the state?
State filed affidavit in opposition in WPC 27, Lordship.
Oh,
The last
2724.
Yes, Lordship.
The
2724.
respondent number 7 filed affidavit in opposition. Where have you stated that you have joined?
Lordship, that my
And
affidavit of
respondent
opposition,
number
Lordship,
7 filed in 6595.
595.
Filed affidavit in WBC 6595 of 2023.
Annexer A, Lordship, page 30 of my affidavit.
Where?
Order. Affidavit in WBC number 6595.
Para 5, page 27.
And order is page 30, Lordship, and 31.
One moment. Wherein? It is stated that the respondent number
7.
7 was released by order dated 6/11/2023. To enable her to join to her new place of posting at 1239 number Vivekananda Harizan LP School. And the respondent number 9 accordingly
Seven joined.
7 accordingly joined on 7/11/2023. Correct?
Yes, Lordship.
Stop. Para. At this stage, comma, learned counsel for the petitioner submits that the petitioner is willing.
Lordship, may I, if Lordship, without recording this, if your Lordship record that as the respondent number 7 already joined and there is a stay order, so Lordship, stay order, vacating the stay order, the petitioner is directed.
You want that order?
Lordship, otherwise it will be difficulty on my part, Lordship.
Okay. Para. Considering the fact that the respondent number 7 has already joined to her new place of posting at 1239 number Vivekananda Harijan LP School on 7/11/2023 before issuance of the interim order passed by this court in WC 6595 of 2023, comma. This writ petition is disposed of, directing the petitioner to join to her new place of posting at what no, school
828 number Radhanagar
at
LPL school,
828 Radhanagar LPS,
Udarband Education Block, Udarband Kachar.
Kachar district, within a period of 1 week,
Lordship, within 10 days. Lordship.
within a period of 10 days, with effect from today. Stop. Consequently, comma, the interim order dated
17/11.
17/11/2023 passed by this court in WBC number 6595 of 2023 stands vacated. Stop. Is there any interim order in the other writ petition?
In 1492, there is no interim, only notice was issued, Lordship. In
1492?
this writ petition, one IA is there, Lordship,
Okay.
499.
With the above directions, this writ petition, both the writ petitions are disposed of. In the IA, you say in view of the order passed in the main writ petition, IA stands disposed.
Lordship, the
content-
respondent authority may be directed to clear my all arrears salary.
Okay, just before it's disposed in the event, comma, the petitioner joins to her new place of posting as directed by this court within the next 10 days, comma, the respondents are directed to regularize the period of absence of the petitioner and pay her salary as entitled to the petition. Stop. And in the contempt, in view of the order passed today in the main petition, contempt petition stands closed.
Contempt petition, your Lordship has disposed it of.
I'm disposing of.
And only 279, 27.
And in 2724/2024, say Hurt Art MS Art Chowdhury, Learned Counsel for the petitioner, on request made on behalf of Mr. A. Fukan, and the standing counsel, elementary education. When do you want?
Day after. Or let's go next week.
Friday, Lordship, this Friday, next week may be a motion week.
Okay, 13th.
Deeply obliged.
Obliged. 19.
May it please, Lordship, matter relates to non-payment of arrears salary to the petitioner, my lord. He is working in a lower primary school.
Fukan?
My lord, can we some time may be allowed? I have not received any instruction.
Lordship, I can note the dates, my lord. First, it was listed on 15/7/2024, then again on 28/8/2024, then thereafter on 2/9/2024. Ultimately on 13th/9, my lord, notice was issued. 8 weeks have gone by, my lord. Still, my lord, no response is there from their side.
Yes.
Only after vacation.
I'll give a fixed date.
My lord.
Heard Mr. M.R. Digade, Learned Counsel for the petition. On request made by Ms. N. Fukan, the standing counsel, elementary education department. List the matter on 6th January to enable her to receive.
20. May I please, your Lordship?
Yeah, my lord, we have received the, I have received the instruction to sometime maybe allowed to file our application.
Here is the covered case, similar case, exactly similar. Earlier 2 occasions Lordship heard the matter. They are disputing not similar. Everything is similar. exactly similar. Paying to dispose the on the same way, denied from 2013. See, every time you were asking not similar, similar. 3/4 of questions already appeared, took time, not saying not similar. I am placing whether it is similar or not. They every time lost, every time they are trying for not similar. From
If
4th,
similar,
5th,
we
5th
have to
occasion already
see
took time.
objection.
They have to verify.
If similar, we have no any objection.
Yes,
But
similar,
we have to
exactly.
verify whether it is similar or
Fourth, earlier 4th
So
occasion
have you
took time.
verified or not? At least you've been given so much time.
I have to verify.
I am placing the facts and whether it's similar or not.
Yes.
Here is the case lordship. In 2011 Act, name of the petitioners along with the employees.
Order to be.
আমার সেভেন্টিনত একমত প্ৰভিন্সিয়েল কৰিব কৰিছে আমাৰ মিটাৰটো বেলেগত চেনেল কৰা নাই and earlier occasions after a name appeared in the list, particularly not province stating that I am not qualified. Then applies I am the qualified, then forwarded my name again the DLC. In the meantime, second, exactly similar. Exactly similar. Without proof. Why I will suppress the thing? May place the first lordship small. Whether my friend will also certify whether similar or not.
Yes.
Yes, lordship. Here is the case. Petitioner appointed a assistant teacher on 10/6/2020. As per the provision of the 2011 Act, the name of the petitioners along with others and particulars forwarded before the government. Accordingly, my name also appeared in the website list on
Where's that list?
that page 28 lordship.
Yes.
That top lordship will find particulars of provincialized venture educational lower primary during 12-13 as per the Assam Venture Education Institution Provincial Services Act 11 as amended and the government so and so. This is relating to lower primary school in the district of Nagaur, lordship. Let's find Nagaur. My name appeared page 29, serial number 87. Name of the school lordship will find address. Then I am Khalida Jia, colon 7 lordship will find first lordship above what Julfikar Ali, Juria block 87. Name of the Uttar Purb Salpara Moktab LP school. Then next column Julfikar Ali, he was the head teacher of the school. And bottom lordship my name will find Khalida Jia, colon 10. My qualification written HSLC, date of joining everything 1+1 2 4. Then lordships provincial list published, that is page 31. That is relating to the district of Nagaur lordship, page 31. That list is 14th May 2013. The 303 numbers of LP schools provincialized and 608 teachers lordship. Here my name, our school appeared lordship page 32. Serial number 84. Next page 32 lordship, left side lordship will find Uttar Purb Salpara Muktab, Julfikar Ali ST, vacant, bottom lordship will find vacant. Against my post, tone vacant. Post sanction 1+1, second 80 post vacant. Then I inquired the matter. They apprised me I am not qualified because I only HSLC. Here is the list you will find. So many teachers also appeared in next column HSLC pass, they have considered. Then I apprised the authority that again my notes forwarded lordship, that is page 37, that I was eligible and again forward page 37. Type copy is the page 37 and original copy is page 40, Lordship. Minus the district student going meeting held on so and so at officer chambers, district elementary education officer, no doubt. Next page, page 38, resolution number 8. It is resolved that DSC has decided to recommend the education qualification of the Uttar Salpara Moktab School under Juria PA. That is in my case. They forwarded that it was forwarded before the Director of Elementary Education, page 42. Regarding release of my vacant post in the Uttarpur Salpara Moktab LP School. With reference subject, I have the honor to state you that the Uttarpur Salpara Moktab is provincialized by order so and so, dated 14/13, with a vacant 80 post due to underqualification of Khaleda Jia, petitioner lordship 80 under B Juria. Now she is become qualified and passed the HS examination in the year 2012. Then they did not consider. I approached this on court, page 48. Along with two other persons. First one is Hamida Begum. That case now I'm placing lordship, similar case it was considered. First one lordship, page 48, Hamida Begum. Second, Khaleda Jia. Now Khaleda Jia is before this report. Earlier,
The second petitioner is the present petition.
present petition.
Okay.
The direction part was to consider their case as per minus during the pendency of the complying with the directions. 2011 Act was struck down. Then came with a notification lordship 29/5/2017, page 54. That is important for disposal present case lordship. Page 54. Issued by the Elementary Department lordship. Page 54, bottom point, date 29th May 2017. Subject to the Deputy Commissioner's call, subject implementation Assam Education Provincial Services of Teachers and Reorganization of Education Institution Act 2017. Your lordship will find bottom paragraph, page 54, bottom. Further, the teachers whose educational institutions have already been provincialized as per the Assam Venture Educational Institutions Provincialization Services Act 2011, but their services have not been provincialized, may submit their application for provincialization of their service under the new Act 2017 in the enclosed format at Annexure A for LP school. Then accordingly, I submitted form lordship, page 57. My headmaster also forwarded. 57, that form forwarded before the authority for provincialization. That was bottom point lordship 6/6/2017.
You submitted this before?
The B form submitted lordship.
No, to whom?
District Scrutiny Committee.
Okay.
As per form, it is provided submitted along with the particulars up to page 61. Then lordships, there in the meantime, 4/2021 and the list published, those who are applied, they are newly applied, their service provincialized. My service has not been provincialized in spite of submitting the form. Then I approached this on court, and similar case Hamida Begum also applied. It was not considered that the present writ petition, she filed writ petition, that is that I have annexed. It was disposed of. That's why I am praying for similar direction may be issued in respect of the present petitioner. That is page 70, start from Hamida Begum's case. From paragraph 4 to onward, lordship will find all the facts stated.
Yes, Fukan, I think it's the same.
Squarely covered. From paragraph 11 of the judgment of page 70, find directions first. Since communication dated 29/5/17 was issued by the Commission Secretary to Government of Assam, Department of Education persons to coming into force to the Act 17, require the teachers like the present petitioner to submit application for consideration of their cases under the Act 17. Such submission or application cannot be an empty formality and must be given its due consideration. The material available on record indicates that the application submitted by the petitioner in pursuant to the communication dated 29/5/17 for having his case considered for provincialization under the provisions of the Act 17 is still pending, inasmuch as no material has been brought on record to demonstrate that such application was considered by the District Scrutiny Committee.
Yes, Fukal.
In view of exactly.
You're not sure.
Any some time will be allowed.
Then we are disposing it off on the next date. You study this case is a simple matter. 2011 time when they were considered, the petition was not
Unfortunately
having
not
the-
considered.
So, madam, dispose of.
Hmm? You want time? I can give you time, but then the next date I'm disposing it off without adjournment. Heard Mr. F. Barwell and also for the petition. On request made by MS N. Fukan, Learned Standing Council, Elementary Education Department. When?
সেইটো সময়ত আমি এফিডেভিটখনো দিব লাগিব আপোনালোকে বস্তু একেদিনাই দিব নোৱাৰো নহয়
Okay, listen. On 6th, opening day, January, huh?
For disposal.
It is made clear there shall be no adjournment on the next date fixed, and this case shall be disposed of positively.
Obliged.
DPO.
3.
Hector?
May it please allow.
All parties are here?
Lots.
Respondent 8. Yeah, pray. KK Hendik Fukal. Okay.
Look, here, Lordship, we have challenged the Lordship appointment of the respondent number 8, Lordship, in the KK Handy state opinion.
Where's that order?
Lordship. Annexure 11, page 41. Lord. Post in the assistant professor in Assamese, Lordship.
Okay.
Here, Lordship, in the column number 5, Lordship, subject to the provisions in the statute, this appointment is made on provision for a period of 1 year from the date of joining. Okay, according to the statutes, Lordship. The main ground of challenge, Lordship, his appointment is, Lordship, that he has not submitted no objection certificate while applying for the post, Lordship, from his previous employer, Lordship. Because at that point of time, Lordship, he was working as an assistant professor in a different college under the Director of Higher Education, Lordship. And he has not produced the required no objection certificate.
Was this selection after an advertisement?
Lordship.
You participated in that?
I have participated.
Okay.
And
Where's the advertisement?
Advertisement, you have, Lordship, kindly have a look at the affidavit in opposition filed by the Lordship respondent number 1 to 6, Lordship. Page
1 to 6.
Lordship. Page continuing page 56, annexure A, Lordship. Relevant page is Lordship. Annexure
Page 60, Lordship.
Yes.
And this is serial number 6, assistant professor, Lordship. Your Lordship, essential qualification was that, Lordship, a master's degree with at least 55% marks on an equivalent grade, so and so, in a concerned relevant allied subject from an Indian university or an equivalent degree from an accredited foreign university, the Gazette of India, so and so. Besides fulfilling the above qualifications, the candidate must have cleared the NET conducted by the UGC or CSIR or a similar test accredited by the UGC like SLATE, or who are or have been awarded PhD degree in accordance with so and so, and their amendments from time to time. Provided the candidates registered for PhD programs so and so shall be governed by the provisions of the then existing ordinances, bylaws, regulations of the institution awarding the degree, and such PhD candidates shall be exempted from the so and so. Now the next is page 61, Lordship. There is a condition, Lordship, that is a desirable qualifications, Lordship. Page 61, Lordship, got it, Lordship? One, a degree, diploma in distance education or working experience in distance education institution, Lordship. Adequate knowledge of computer, proficiency in both Assamese and English language. And my lord, here, Lordship, we have another ground challenging the appointment is that, my lord, the respondent number 8 does not possess this desirable qualification, Lord. That is,
It's only a desirable condition qualification. It's not a requisite qualification.
but my lord, it is under the statute of the KKND State Open University, desirable condition, Lord. It's in violation of that, Lordship, statute, Lord.
Okay, that we'll see, but then see the requisite educational qualification.
That is
It is
covered.
there.
That
And
is,
the rest is, if you have,
Lordship.
it will be desired by the antique university. It's a
Then-
desirable qualification.
But
Even if you don't have, it would make a difference.
But
But if you have, maybe you can get some preference.
Lordship. But the only thing is that, Lordship, the mark which has been allotted under this ODL heading, he was allotted that marks, Lordship. He was allotted marks in the ODL experience heading in the.
Okay.
Kindly have a look at that compilation of marks at page, Lordship. It starts from page 62 of the same affidavit, Lordship. Page 62. 2, 3, 60, Lordship. Kindly have a look. Page 64, Lordship.
Page 64.
64, Lordship.
Okay.
Here, Lordship, the serial number 10, that is respondent number 8, Lordship.
Okay.
He was given marks in the ODL experience heading, that is 2 marks has been allotted, Lordship, by the interviewer. One, that is one interviewer, I.K. Bhattacharya, then Tiny Deka, page 65. It was also given number 3. FP.
Where's your name?
My name is serial number 8, Lordship. 5. I was given 5, Lord.
Rumuni.
Runmoni.
Huh?
Runmoni.
You were given 3.
Respondent number, I was given 3 by one interviewer, I.K. Bhattacharya. Then page 65, Tarini Deka, he has given 3 to the respondent number 8, 5 to me. Then Dipti Fukan Padpiri, he has given 3 to the respondent number 8, 5 to me, Lordship. And next one is the Vice Chancellor of the university. He has given 3. And with the petitioner 5, Lordship.
Okay.
Here also, I want to point one thing, Lordship. Here also, kindly will page 67, Lordship. Is a marks by the Vice Chancellor, Lordship. And there is a overlapping, Lordship. Page 67. In the serial number 10, last 24 was allotted interview subject knowledge, but it was overwritten, Lord.
But he has countersigned it.
Countersigned, Lord.
Anyway.
You know, my main challenge is that maybe if a person does not possess a particular qualification in a particular heading, how he has been given marks, Lordship, in the interview, Lordship. Because if your Lordship kindly read the application submitted by the respondent number 8, he has not mentioned about the ODL experience. And university authority is also silent. Well, I have made categorical statement regarding that respondent number 8 does not possess the ODL experience. The university authority in their affidavit has not denied that statement, Lordship. It leads to the fact that they have not possessed the ODL experience at a particular time of interview, Lordship. And he was given marks. And moreover, my lord, if we go by the compilation of marks, we have found that, Lordship, there are 5 interviewers, Lordship, in the selection process, Lordship, 3 experts and 2 from the university authority, like the vice chancellor and another one is director of another school. So here we have found that, Lordship, there are more than 5 marks difference from the university authority and the expert body, expert selection panel, Lordship. So there is, Lordship, some biasness and favoritism on part of the universities there, Lordship. And Lord, why I'm submitting, Lordship, your Lordship, out of Lordship record, I have to submit that, my Lord, the Vice Chancellor, Lordship, here, Lordship, he has been terminated from this university because of some illegality committed by in the Guwahati University, also here, also, Lordship. And Lord, my learned friend Upon is also against a particular Vice Chancellor, Lordship, and the proceeding is also before this Honorable Court, Lordship. This case is conducted for Decca, Lordship. Well, there is some biasness, favoritism on part of the Vice Chancellor also, and we have categorically mentioned in our petition also, Lordship.
You are alleging Malafide?
Lordship.
Have you met him a party?
No, the Vice Chancellor, Lordship, is a party, Lordship.
By name?
No.
Then, if you are alleging Malafide against him, you have to carry him by name.
Lordship. But my main practice is that my ODL experience.
Okay, fine. So your main ground is that the private respondent does not have the ODL experience and therefore marks could not even given to him.
Lordship. And Lord, next one is NOC, Lordship. He has not submitted the no fiction certificate from the concerned previous employer, Lordship. While he was working as an assistant professor in a particular college, Lordship. Okay. He has not produced, Lord. But he was allowed to sit in the interview and he was shortlisted, Lordship. But Lord, there is a condition in the application itself that
where's that provision that NOC has to be there?
In the Lordship, in my petition, Lordship.
No, it will be in the advertisement, isn't it?
Advertisement, it was not there, Lordship. But my Lord, in the application, Lordship, kindly have a page 23, Lordship.
Page
Page 23 of my petition, Lord.
Yes.
Lordship, last general information, Lordship. That Lord, those that are already in service shall have to apply through proportional, Lordship.
Okay, we'll continue to.
Lordship. Problem.
Lordship queries some, made some queries regarding the increment. What happened to the increment that was lost by issued by the director? State the increment. Now the secretary has issued a clarification order whereby appeal was disposed of. A fresh inquiry has been issued. Till then, that the impugn order, Lordship of the director imposing a penalty of withholding 5 increment has been stayed till the completion of the fresh inquiry.
State or
that is state because that has to be determined. That has determined by a fresh inquiry only. Only through a fresh inquiry we can determine whether that will be the imposition was correct or not.
Fresh inquiry?
Yes, Lordship. And the direction was to considered the appeal only. There is no direction. He will file an, we have considered the appeal.
Can you have a fresh inquiry?
Let him have, if they are agree.
Anyway, of course, that I'm not.
Agree, they can come, but so far as the content is concerned, we have complied.
Well, the issue is that the appeal was to be disposed of by a speaking order. Well, there is no, he has not come to a finding that the imposition is good or bad. He has simply set aside the matter and directed the director to take a fresh decision and has stayed the order. He has not even cancelled the order.
There is no question of cancelling, Lordship.
This is total non-application of mine, my lord.
Well,
It simply has passed on the buck to the director.
Yes, that only after fresh inquiry we can come to the conclusion whether that was right or wrong, whether that can be imposed or not.
So, my lord, a person has been, my lord.
See, there are two things.
Yes, Lord.
First thing is that on the inquiry of the first inquiry,
Yes, Lord.
petitioner was imposed this thing, then he went on appeal.
Yes.
All these things.
Yes.
So this court, what was the
regarding
This was the appeal, my lord.
To dispose of the appeal.
Appeal, my lord.
All right.
Appeal. Only to dispose of the appeal.
Only to dispose of the appeal. Now, the appellate authority has directed the disciplinary authority to conduct a fresh inquiry.
Fresh inquiry.
Now, can the earlier punishment be
that has been stayed, Lordship?
How can it stay? It has to go. Because now the fresh inquiry will come.
Yes.
On the basis of the fresh inquiry, if found that guilty, fresh punishment will be given. But then the first inquiry, when when the appellate authority is directed the disciplinary authority to conduct a fresh inquiry, then that earlier punishment will have to go.
That is why it is stayed, Lordship.
It can't be stayed. It has to be gone.
And a direction also to consider to consider the appeal. So we have considered the appeal, Lordship. If he has any grievance, he can challenge this, Lordship. So as contempt is concerned, we have to consider the appeal. So we have considered the appeal.
Well, it's neither here nor here, there, my lord. He is neither disposing, he is not saying that the order is bad.
In contempt,
he is only staying it, my lord.
Lordship. What was the direction to consider the appeal? He will file appeal, we will consider. So we have come to a conclusion. If he agrees with the conclusion, he can challenge this, Lordship.
He is a secretary of the department, my lord. He doesn't know how to dispose of an appeal, my lord. Very strange, my lord. Very, my lord, unfortunate, my lord, I would say, my lord. He is, my lord, not interfering with the earlier order. He is saying you stay. That means, my lord,
interference is there.
Yes, my lord.
Yes, no.
My lord, the punishment is still there. It's been stayed, and the person is, my lord, the department is not sure whether the earlier imposition was right or wrong. And yet, my lord, the 5 increments have been withheld, my lord, for so many years.
And court didn't interfere with his interference, Lordship. Court didn't state that Lordship. Court has stated only to file an appeal and it will be considered.
It was an appeal to be disposed of.
Court didn't give them any relief, Lordship.
No. The issue is this. Court directed the appeal to be considered and disposed of. Correct?
Yes.
The appellate authority has disposed of the appeal, directing the disciplinary authority to conduct a fresh inquiry.
Till then, yes, Lordship.
Till then, that
punishment has been stayed.
Yes. But then, when the appellate authority directs the disciplinary authority to conduct a fresh inquiry, that means the other inquiry is gone.
That is gone only after the conducting of the Lordship inquiry.
That first inquiry is gone, and any consequent orders out of the inquiry report also goes.
Whatever that will be a subject of writ petition, Lordship. Using contempt petition, whether we can go to that, Lordship.
Of course, that is a different thing. But then this is not the way to be doing things. Again, the petition has to come before this court.
He's just 1 year of service left, man.
And the contempt also that direction in the writ petition only to dispose of his petition, Lordship. Not come to any outcome. Not to Lordship his.
In the appeal.
That's fine. The only thing is this.
There is no mandamus in this writ petition, Lordship.
This is a contempt jurisdiction. Of course, they have done it. But then it's not the way to do things.
That I will convey, Lordship. But so far as technically, Lordship, in contempt, direction to petition,
I understand.
there is no mandamus in favor of the petition.
My learned friend is saying there is no, my lord, direction to provide any outcome. Then what is the point of disposing of the appeal, my lord? He is an appellate authority. He has been given particular mandate, my lord, under the rules. He has to decide whether the author of the lord.
Anyway, we can close the content. You can challenge this order.
Yes, my lord. This sort of challenge, my lord, again, my lord, this entire process has been now stayed, my lord. The inquiry is now, he's without, my lord, he'll be without his, my lord, increments. At the same time, my lord, he has to face an inquiry. We don't, because the department itself is not sure whether the earlier order was right or wrong. That's what they're saying. It is dependent on the fresh inquiry.
And even the court didn't give you any relief, Lordship. No, it's not a question. The court did not give the authority may not know anything. The court didn't give you any relief. Court did not give the relief because the appeal was pending, my lord. No, not because of anything else. This order, my lord, is neither here nor there, my lord. Just to, my lord, discharge his burden, my lord, in terms of court's order, my lord, he has just, my lord, passed on the buck.
Anyway, we'll close the contempt. You file your
Yes,
file a writ petition challenging this. This is not maintainable. I mean,
That report will decide. Okay.
Of course. Heard Mr. M. Datta, learned counsel for the petition. Mr. SMD Chishti, learned counsel for the response number 3.
No, Lordship, will be responding number. I've been directed by the Honorable Court to appear. Lordship for his response is actually 1, 2, 1 and 2. 3. Madam Court.
Has submitted an order, has furnished an order dated 10/12/2024, issued by the Secretary to the Governor of Assam, Department of School Education, wherein it is indicated that the Director of Elementary Education has been directed to initiate a fresh inquiry following all the provisions of the Assam Service within bracket Discipline and Appeal Rules 1964, and to complete the process within a period of 1 month. The order further indicates that the order dated 29/9/2012 passed by the Director of Elementary Education Assam, imposing a penalty of withholding of 5 annual increment is state till completion of the fresh inquiry. Stop. Para. On the perusal of the order dated 10/12/2024, this court is of the considered opinion that the respondent has substantially complied with directions passed by this court, and accordingly, contempt petition is closed. The order dated 10/12/2024 is placed on record. You have liberty to challenge.
Yes, yes, obliged.
Item 3 will continue.
Lordship. Earlier I have made submission that, my lord, the respondent number 8 does not possess the audial experience, Lordship. In spite of that, Lordship, he was given marks in that heading, Lordship. And to substantiate this, Lordship, kindly have a look at the affidavit in opposition filed with the respondent number 8 himself, Lordship. The application, Lordship.
Affidavit in opposition.
Opposition filed by the respondent number 8. Starts from, Lordship, page number 113, Lordship, and relevant is page number 139, Lordship. Continuing page 139.
Yeah.
Lordship, got it. And it's paragraph number 16, Lordship. Below, Lordship. Experience, and heading B, Lordship. Experience of working in open universities, ODL institutions, and he does not feel it. But it means that he does not possess, Lordship.
Yes.
In the university authority also, in their affidavit in opposition, in regard to my, and have a look at my statement in the writ petition at paragraph number 18, Lordship. Page 10 of my writ petition, Lord. Paragraph number 18, that it is stated that it is a specific knowledge and information that petitioner that the respondent number has. It has no such experience of ODL as required for the post of assistant professor in the university.
Para 8.
Para 18, Lordship. 18, paragraph, page 10, Lordship. Oh.
Paragraph 18, paragraph 10. 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 18, para
Last line. It is a specific knowledge and information of standard. The respondent number 8 has no such experience of ODL as required for the post of assistant professor in the university. And in regard to this lordship, the affidavit in opposition filed by the university authority, kindly have a look, lordship. Page 51, lordship, paragraph 19 of their affidavit. Got it, lordship? That the statement made in paragraph 18 of the writ petition are stoutly denied by the answering deponent, and the writ petitioner is put to the restricted proof of those statements by adducing causal evidence. The selection committee has shortlisted 3 candidates considering their merit position, and the respondent number 8 has been selected for the post in question only upon his merit. In fact, the allegation raised by the writ petitioner has no legs to stand before this honorable court.
And what is the private respondent saying in the affidavit?
Lordship. Page, lordship,
Para 14.
lordship.
Page
Paragraph
127.
14, lordship, page 127. Lordship, that with regard to statements made in paragraph 17, 18 or 18, the deponent begs to state that the deponent believes that he has a good academic career with first class first position in all examinations from SSLC to MA, and therefore he has been shortlisted, selected, and further did well in the interview held on 9/10/2020. Therefore appointed by the selection committee. This is the lordship. And the allegation level against the deponent is vehemently denied by the deponent.
Okay.
He has not denied it, my lord.
So your ground is 2 grounds.
Lordship.
No ODL
No ODL actually.
and no objection certificate.
No objection certificate. And other thing is that while appointing and selecting his lordship, the ODL experience has been considered as a factor, lordship. As a factor, the ODL experience has been taken as a factor for selecting. Lordship. Kindly have a look at the lordship.
Where is that?
Their affidavit, lordship, of the university.
Where is that advertisement?
Page 72, lordship. Affidavit of the university.
One.
Continue. Continue to 72. Oh, lordship, got it, lordship.
70?
72, lordship.
Yes.
Yes, proceed. A lordship, assistant professor in Assamese. It's an abstract of the proceeding, 19/2020. The meeting of the selection committee was held on 9/10/2020 at the city center of the university at Khanapara. Total 10 candidates were shortlisted and called for interview, out of which 7 candidates appeared in the interview. The committee, after taking into consideration of the academic credential, experience of ODL lordship, and knowledge of computer and performance in the interview, unanimously decided to recommend the following candidates for appointment in order of preference: Dr. Sanjeev Bora, respondent number 8, Runmani Bora, petitioner, and Tolleti.
Petitioners number 2.
Number 2, lordship.
Okay.
It was considered, lordship, but he has not that qualification of ODL experience, lordship, which is required, lordship. And even, my lord, kindly have a look at the KK State Open University is meant to provide open and distance education to the students of Assam, lordship. And here, lordship, kindly have a look at the first ordinance of the university. Page 22, this is the lordship qualification for the lecturer, assistant regional director. There is also a desirable condition is a degree diploma in distance education, experience of working in open university distance education system, Lordship. The ordinance is itself, Lordship, provide that one has to, they desire the persons with those experience, Lordship. Because KK State Open University is a university constituted for providing open and distance learning, Lordship. So ODL, Lordship, that is open and distance learning experience is a desired condition, Lordship, and that is violated by the selection, Lordship. These are commission, Lordship, but is it the violations of ordinances, Lordship, made by the university authorities and irregularity caused by the university authority by selecting the respondent number 8? Okay, because, my lord, the ODL experience which is required, Lordship, and which does not at all possessed by the respondent number 8, he has been given marks, Lordship. And moreover, my lord, if we go by the compilation of the marks, Lordship, there is a huge difference by the marks given by the expert panel and the university panel, Lordship. I'll show it, Lordship, if required, Lordship, from the compilation. It is a
Where is that compilation?
Lordship. In the affidavit in opposition filed by the university, Lordship. Annexer C, page 63, Lordship. Take my affidavit in reply also, I have made some Lordship table, Lordship, regarding this, Lordship.
Where is your name?
I'm at serial number 8, Lordship.
In this page 63?
Page 63, Lordship.
So you got 71?
71, you was given 74.4.
And where's the other thing, the respondent?
Respondent number 8 is serial number 10, Lordship.
Sanjeev Bora.
Lordship.
Okay.
Lordship, in my affidavit in reply, Lordship, I made a table, Lordship, regarding the consolidated mark sheet, Lordship. It will be clear, Lordship, page 84, Lordship.
Page?
Page 84 of my reply, Lordship, affidavit. Continuing page, Lordship. Lordship, got it. Page 84.
Yes.
Page 84, Lordship. Here, the first 3 members were the Lordship expert panel, Lordship. The difference of marks between the petitioner and the respondent number 8 is like 1.2, 2.2, and 1.2. But the university authority, that is the vice chancellor and chairman of the selection committee, the difference is 5.2 and 5.2, Lordship. There is some irregularity on their part, Lordship. And there is also some overwriting of marks also in the marks allocated by the vice chancellor, Lordship.
Okay.
There is some irregularity on their part, Lordship. Now, Peter, and my lord, next one is receive NOC. They have not submitted the NOC, which is required, Lord. So kindly have a look at my petition. I have placed one, Lordship, guideline.
In your petition?
In my petition, Lordship. Page 44, Lordship, Annexer 13.
Oh.
Then actually is a circular 22/6/2017. They mention about the rule 24 of the Assam College Employees Provincialization Rules 2010, Lordship. Here it refers, Lordship. May I read, Lordship? No objection certificate for higher studies and applying for job. The governing body shall issue NOC to the college employees for applying for admission to course of higher studies and for other jobs. Since various employer demands an NOC from the present employer, this office has been issuing NOC to teachers to apply elsewhere. It is clarified that an employee who has accepted employment by way of direct recruitment in a provincialized college cannot claim NOC as a matter of right. The governing body or the principal can decline recommendation for NOC if they think that absence of the teacher will adversely affect the students and the academics of the college. The office will not issue any NOC except when recommended by the college authority. An NOC issued from this office will not entitle an incumbent to claim retention of lien on his substantive post as a matter of right. It is further clarified that each college is a separate cadre for each category of employees as per Section 3C of the College Employees Provincialization Act 2005. Instances have come that an employee joining from one college to another on an NOC has claimed and availed seniority of past services. Past service cannot be counted towards seniority in another college except approved by government in each case. This is the circular law. And here it says that the NOC is required. But admittedly, he has not submitted the NOC, Lordship. In this regard, Lordship, I have submitted some judgments, Lordship, regarding the advertisement and marks, etc., and illegality caused, Lordship. These are the judgments, Lordship. And read some small paragraph, Lordship, I just want to point out. If your Lordship permits me, Lordship. First one is, Lordship, 2013-11 SCC 58, Lordship. It is only paragraph 20, Lordship. Page 14, Lordship. May I read the paragraph 20, Lordship?
Yes.
This court held lately held that a person who does not possess the requisite qualification cannot even apply for recruitment for the reason that his appointment would be contrary to the statutory rules.
This is not applicable to your case.
But let's say, as per the statute and ordinance, it is required, Lordship.
It is a desirable qualification. The only question is, if you don't have the ordeal, how marks were given for the
Lordship, that
ordeal,
is
that's
the
all.
that Lordship.
Yeah, what is your other case?
Lordship, then others are same, Lordship, requiring that cannot.
How about the NOC?
NOC, this circular will cover, Lordship. And my lord, it's in violation of ordinance, Lordship. Kindly, my lord, 1993 supplementary 3 SCC 168, Lordship. It's regarding violation of ordinances, Lordship. Paragraph 11, page 24, Lordship. Page 24, Lordship, point A, Lordship. The university must note that the qualifications is advertised for the post should not be at variance with those prescribed by its ordinance statutes. So, this ODL experience is as per their ordinance.
Oh,
Not
that was there.
But my lord, he does not possess the ordeal experience, Lordship. He was shortlisted, accordingly allowed to speak in the interview, even marks, Lordship. Everything was there, is everywhere illegality, Lordship. That's why.
Yes.
Yes, sir.
Lord, I take your lordship straight to my affidavit in opposition. There are two aspects, one regarding NOC, and second one ODR. First, Miller, at NOC part. My affidavit in opposition, filed by respondent number 1 to respondent number 6, University. Internal page 3, Miller, paragraph 6. Merit. That as regards the statements made in paragraph 4 of the writ petition, the answering deponent begs to state that the condition for no objection certificate from the employer was only directory in nature, and said conditions were not mandatory, that is, cannot be essential condition. In fact, the required qualification and requirement for the post of assistant professor were uploaded in the website of the university, in as much as no objection from employer cannot be considered as required qualification for any eligible candidate. I will refer to the UGC regulation regarding NOC little bit later. There is no such requirement, more particularly essential requirement regarding NOC. Next paragraph. Paragraph 7. As regards the statements made in paragraph 5 of the writ petition, the answering deponent begs to state that 7 candidates appeared before the selection committee on 9th October 2020, out of which 3 candidates were shortlisted by the selection committee. The respondent number 8.
Reading from
Paragraph 6 and 7, Miller. Page 3. Internal page 3, Miller.
Yeah.
The 6 is regarding that directory nature of NOC, and this paragraph 7 is regarding the marks obtained by the private respondent as well as the writ petitioner. I'm again reading this paragraph 7. Regard the statements made in so and so, answering the opponent begs to state that 7 candidates appeared, paragraph 7, Miller, before the selection committee on 9th October 2020, out of which 3 candidates were shortlisted by the selection committee. The respondent number 8 was at first position with 74.4 marks, total mark 372, awarded by 5 experts, and the writ petitioner was at second position with 70.4 marks, total mark 352, awarded by 5 experts. The minutes of the meeting has been annexed as Annexer B, and the consolidated score Annexer C. Now, kindly turn to para 12, page 5. That as regards the statements made in paragraph 10 and 11 of the writ petition, the answering deponent begs to state that since the NOC is not a mandatory or essential qualification for the post of assistant professor, the selection committee rightly allowed the respondent number 8 and Dr. Pallabika Sharma to appear in the interview process. That Dr. Pallabika Sharma also does not have that NOC. It is mentioned here in that the selection and appointment for the post of assistant professor at university is governed by University Grants Commission Act as well as rules framed thereunder. The UGC regulations on minimum qualification for appointment of research and other academic staff in universities and colleges and measures for maintenance of standards in higher education 2018 is holding the field for appointment of assistant professor at university, and such regulation of 2018 do not insist upon any NOC from employer. Therefore, the selection committee allowed candidates to appear in the interview without insisting upon no objection certificates. Now, my lord, we can skip other paragraphs. Paragraph 28. Internal page 10. That as regards the statements made in paragraph 30 of the writ petition, the answering deponent begs to state that the recommendation of the selection committee was placed before the Board of Management for approval, and the Board of Management in its 59th meeting dated 19/10/2020 approved the recommendation of the selection committee in favor of the respondent number 8 by the resolution number so and so. Accordingly, appointment order dated 20/10/2020 has been issued by the university, and subsequently the respondent number 8 joined the post in question on 7/11/2020. It is further stated herein that before joining the post in question, the respondent number 8 submitted his resignation before the principal, Prague College, on 6/11/2020. So, my lord, he tendered his resignation in the earlier.
That's fine. That's fine. I'm not going into all this.
My lord. So, my lord,
The respondent number 8 did not have the ordeal experience.
my lord, the NOC, my lord, aspect.
NOC, have not, let us not go into this.
Now,
Let us go on the ODL.
ODL. Now, kindly turn to my affidavit in Annexure C, my lord. Page 19. The consolidated statement.
Yes.
Page 19. Annexure C. Consolidated score sheet of the candidates. The seventh one, Pallavika Sharma, she got third position. Serial number 8, Runmoni Bora Fukonda, the read petitioner, second position, got 71.4. And Sanjeev Bora, serial number 10, the private respondent number 8, who got selected, 74.4 at first position. Now, regarding this ODL experience, the score sheet of 5 experts. Next, page 20. 20, 21, 22, 23, and 24. Next, page 20. Miller, seventh column, Miller. ODL experience, and next, SLM in ODL. In ODL experience, Runumoni Bora Fukon read petitioner got 0.3. Sanjeev Bora got 2. And in SLM in ODL.
What is SLM?
Study level material. And
Study and learning material, not
study and learning. I'm sorry, my lord. SLM in ODL. Total 5 marks. Sanjeev Bora got 0. And read petitioner got 5. Now kindly turn to next page, 21. Runmoni Bora Fukon read petitioner got 5. Sanjeev Bora 0. And next page.
Sanjeev Bora got 3 lot ODL.
No. SLM in ODL. I'm referring only on that column. The next page, page 22. Read petitioner got 5. Sanjeev Bora got 0. Page 22. Then 23 and 24 also, Miller. Read petitioner got 5. Sanjeev Bora got 0. And again in page 24, Runmoni Bora Fukon read petitioner got 5. Sanjeev Bora got 0. So in ODL heading, Miller, SLM in ODL, Miller, since he has got no SLM ODL experience, so he got 0. But in ODL experience, it should be, Miller, experience, Miller, teaching experience.
How can you say it's a teaching experience?
Miller, otherwise, Miller, this experience, Miller.
No.
Kindly turn to the.
This court will have to go as per the records. You can't change it. ODL experience means it's ODL experience, nothing else.
Miller,
and the respondent number 8 does not have any ODL experience. Therefore, no marks could have been given to him. Therefore, the whole proceeding stands vitiated. Has to be set aside.
Miller, I don't have the records right at this moment, Miller. But this teaching experience, there's
no teaching experience. It's
that
ODL experience.
But the UGC regulation is clear, Miller. So, Miller, the UGC regulation of 2018, there is no marks. Otherwise, there would be no marks for teaching experience. For ODL, Miller, for ODL, there are 2 columns.
That's why.
So, my lord, it's a typographical mistake. One should be teaching experience, and one would
Have
be.
you stated that in your affidavit that this is a typographical mistake?
My lord,
Nothing.
I have not stated, but
Nothing.
the records will clarify, my lord. My lord, anyway, my lord, I will refer the UGC regulation, my lord.
Let us see. UGC.
2018 regulation. Ek minute. Table 3A, teaching experience, teaching postdoctoral experience, 2 marks for 1 year each. He has got 2 years, my lord, 1.5 year, in fact, my lord. So, my lord, per year 2, so he got 4 marks.
Oh,
my lord, Sandeep Bora. One and a half marks. So, some experts, my lord, gave him 3 marks, and one expert has given him 4 marks, and one expert has given him 2 marks.
Where is the teaching experience?
My lord, down below, my lord, that is table 3A. It is for university, my lord. Assistant professor meant for university, my lord, not for college. 3B, table 3B is for college.
Table
3B is for college.
3.
Not applicable, my lord. That page, my lord.
3A. 3A.
3A. Down below, my lord.
Down below.
Teaching. In the middle portion, my lord. Teaching public postdoctoral experience.
Okay.
2 marks for each year. So he has got 1.5 year.
Oh,
my lord, Sandeep Bora, the private respondent number 8. So, my lord, in the experience column, my lord, sometimes he got 4 marks, sometimes 2, sometimes 3. My lord,
how can it vary?
My lord, since
supposing we say, okay, ODL expense is a printing mistake,
my lord,
or it was some due to some advertence.
That
Now
affects
the
some
the UGC regulation clearly provides
2
that
marks for
2 marks for every 1 year.
every 1 year. He has got 1.5 years. So that fraction, one expert, my lord, interpreted is at 1 year. So gave him 2 marks. One expert considered it as, my lord, 2, equivalent to 2. So he gave 4 marks. And other 3 experts gave him 3 marks each. 3 experts gave him 3 marks. That should be appropriate, my lord. Mathematically appropriate. But one expert gave him 2, and one expert gave him.
Mr. Foucault, whatever you say, whatever may be the UGC regulation, this court is not disputing on that issue. But then the chart under which you have given the marks provides for ODL experience only, not teaching experience.
One thing
now
is,
you cannot change by way of a submission
Miller,
that this
know.
ODL experience is the teaching experience.
I cannot, Miller, change the Miller.
And the respondent number 8, as he did not have any ODL experience, could not have been given any marks in this column. And therefore, when marks were given, the whole selection proceeding stands vitiated. Look, this will have to go.
Miller, one thing is clear, Miller. Your lordship will consider
You have a
there cannot be 2 columns for
what
ODL.
is SLM in ODL?
That is why, Miller. That
What
is only a
study
typographical
level
mistake.
Study level?
Study level material.
Study and learning material. Lordship, here, Lordship. I'm going, Lordship. This
One
one,
minute.
Lordship. This books, Lordship.
So there cannot be 2 ODL experiences, 2 columns. That is why record should be required, Miller. Miller, I will produce the record.
Submitted by an affidavit, Lordship. There will be now.
So why did you bring the records?
Miller, today
Every
I'm
Lordship
little bit
details they are
Miller,
submitted by way of an affidavit, Lordship.
not well.
In minutes of meeting, the compilation sheet, Lordship.
See, I've made my mind very clear. Now, even if the records comes, it's on the basis of this on the basis of records
Miller.
that you have made this copy.
Miller.
You can't change this.
Miller. I also agree with your Lordship, Miller. I cannot change, Miller.
Then how do you give marks to a person
But
who
if
does
there
not
is
have any experience in that field?
But my lord, prima facie, my lord, there cannot be two columns without any teaching experience anywhere in the chart. It should be as per the UGC regulation. One, normal experience, and second, ODL experience. So in the ODL experience for SLM, he got 0. But in normal teaching experience, sometimes he got 3, sometimes 2, sometimes 4, due to that fraction 1.5. But I will have to, my lord, show before your lordship.
I'm not accepting your submission.
But that record will clarify, my lord. If the record also, my lord, shows that it is only ODL experience, then how could they, my lord, differentiate ODL experience and SLM ODL experience?
You are a standing counsel.
My lord. That is why, my lord.
You should be fair. When you have given marks in ODL, when the petitioner, when the respondent 8 did not have any experience, then the whole proceedings stands vitiated, and this court will have to quash and set aside this proceedings. You can proceed for a fresh advertisement and have a fresh selection.
So at least one opportunity, my lord, within 2-3 days, my lord, I will produce the records. And if the records, my lord, shows, otherwise, my lord, one ODL heading, he got 2 or 4 or 3, and another ODL heading.
Fukan, it says ODL experience, and the other one says SLM in ODL.
My lord. So in particular that column, my lord, he got 0. All the 5 experts have given 5 marks, 0 marks. But in another column, that was meant for normal teaching experience.
You produce the records, we'll see.
Miller. Only on that aspect, Miller.
Heard, Mr.
R. Fukan.
R. Fukan, and counsel for the petition. As well as Mr. A. Fukan, the standing counsel, AK, this thing, and Mr. S. Balua for the respond number 8. Mr. A. Fukan, the standing counsel, so and so, KK, so and so, shall produce the records. List on.
But next week on Thursday,
19 lot.
Miller.
This matter we kept the part or not.
It will come up. It will come up.
Miller, not F on Miller, please F.
Okay.
22 hearing.
In this matter, my lord, there is a direction of this Honorable Court in 2019, and some implies gadget regarding the utilization. 2019, my lord.
Order.
Order.
What order is it? 4/12/2019? Yes.
There is in paragraph 15, my lord. There is a direction for investigation by the Chief Minister, my lord, of Vigilance team. But somehow this order has not communicated to the CM Vigilance.
What are you saying, Mrs.
My
Saikya? In 2024, you are making a submission that you have not forwarded this order to the CM Vigilance.
My lord.
How?
Earlier, my lord, some counsel who appeared in this matter, my lord, talk with him, my lord. Today he is on leave.
Who's the counsel?
My lord, B. Devi was there, my lord. May pray, my lord, may done some time, my lord, we communicate. But my lord, otherwise,
I'm not saying anything. I'm just adjourning the matter. Heard, Mr.
SK.
S.
SK now.
SK Royal and the counsel for the petition. Last time also this court had already passed that order on request made by Mr. P. Saikiel and the Government Advocate Assam. How much time?
My lord, after Bihu vacation. Bihu.
3 weeks time is allowed to enable him to take instructions with regard to the outcome of the investigation directed by this court at para 15 of the order dated 4/12/2019. Stop. List on after Bihu you want?
After Bihu.
Okay, 24th. 23rd January 20.
That's
Okay.
Lordship, here in this matter, I have received some telephonic instruction, Lordship. Let me have that instruction in written and place before this court, Lordship. Because, Lordship, in this matter, the respondent number 11 who was selected, she resigned, Lordship. Thereafter, Lordship, the post became vacant, Lordship, and it was duly advertised and someone else got appointed, Lordship, now. So, Lordship, otherwise, Lordship, without that instruction, Lordship, it will be difficult to dispose of this matter, Lordship.
Any interim order, Mahmood, in this case?
No, there is no interim order. No.
Okay.
Happily, the children will be.
Mr. M.E. Mahmood, learned counsel for the petition. On request made by Mr. D. Ubamanial and the Standing Council Higher Education Department. When do you want?
Okay. After vacation.
List the matter on.
Otherwise, immediately after vacation. I have no information whether she has resigned or not, but my learned friend is saying.
7th.
Yeah, like.
24 to 27.
All these cases are related to pensionary benefit of the petitioner. For the convenient, Lordship will take the item number 25, 4012, 2023. That case may be first, second part. They all are similar facts in fact that the affidavit file are also in the similar one, and the except the date of retirement, all the annexer we have annexed are the same. Therefore, you kindly take the item number 25, 4012, 2023.
Yes.
The 4012, 4012. The petitioner before your lordship are working as a assistant teacher of a primary school. They are all of petitioner is serving more than 30 years in service. After the process of appointment, they were wrongly terminated from the service on 1992. They have opposed this honorable court.
How many petitioners? One.
No, this is one.
Oh.
This is one. Others are the same. I will going there. I will indicate it already initially from the initial time. They are all always filed petition together. This petition lawsuit find is based their service were terminated. They oppose this honorable court. I am giving the brief case of this. Honorable court set aside their termination order and reinstated the service. That order attained finality. There is a line indicated there that if the petitioner is found to be irregular, illegal in it, he may take action by issue due notice and procedure you can do. But the government have not taken any action on that. They are continuing their service after reinstatement. They are sent to the basic training which is required for it. Government send them. They have already completed their basic training and they get a regular pay scale and they enjoying their. What has happened on 2007? Suddenly their salary has been stopped. They again oppose this court. The honorable court, I've annexed all this document. I'm listening. Honorable, after hearing the parties, they said that as the earlier order of 95, this of this court is attend finality, and you cannot stop their salary. They directed to release their salary. The government came for a review of that order, that also dismissed. Thereafter contempt, they released the salary as they are longer periods that their post has already been, there's no retention, they get a superannuation period and thereafter salaries were released up to 2014. After that, 2015, most of the petitioners 2015 only except two are retired from their service. After retired, their pension is have not released. The GPF amount also not released. After the filing of this petition, this court direction, their GPF amount has been released.
All petitioners.
Oh, all petitioners except one. All petitioner has been already been released. This is the facts list to the case. Thereafter, the government filed an affidavit. In all cases, they filed a similar affidavit. They said they are terminated teacher and their appointment is not good. They are terminated teacher. They are not entitled. Without indicating that they are all the termination order already been settled by this court. They also said, very interesting, I will showing the lots of all this thing. They said there is a cabinet decision on that, and all petitioners of that area has been accommodated earlier. Those who are having passed out basic training, they are in assistant teacher and others are in tutor. And that decision is taken place 2019. We retired on 2015. Now I'm going to there is a stereotype affidavit file. They have not controverted that my appointment. They are not controverted all these statements I have made. They said their name has been included in the list for accommodating nature, and but as they have already been retired, they could not be accommodated. I have retired on 2015. The cabinet decision is 2020. Screening committee is 2000 sitting on 2016. Much after my retirement. And they said that is why I am not entitled for the salary. That is their case. Now Lordship will find what is page. I'm slowly Lordship I will going. And I will placing the after placing the decision and all this. Page 26. And the starting the judgment started page 28. The first case.
No, your appointment?
It is CB rule 61793.
No, your appointment order?
Appointment order Lordship annex 1. No, it is about the essential. It is on 1989.
Okay.
And after I was able to find the page 26, the judgment started from the page 26, 617, 1993. And the petitioner name indicated there,
You don't have a typed copy of this.
Type copy is not, if not required, I can provide it a type copy. And thereafter, I'm just, if not required at that time, I will try giving type copy, no problem. And it did, Lordship will find in page 29.
Where's the petitioner's name?
No. Petitioner name is serial number 31.
Okay.
Page 27, and the operative portum Lordship will find in page 29. May I do slowly? In BOT matter, Annexa 3 series cannot be stand, and accordingly, Annexa 3 series order of terminating service of the petitioner shall stand first. The petitioner shall be reinstated in their service. It is made clear if there was any irregularity, so not illegality, so irregularity, in making appointment, the authority may take action after giving notice. The petitioner and pass necessary order in accordance with law, but the petitioner shall be reinstated.
What it says in the preceding para?
Reinstated time. A BR perusal with Annex 3, the order that 1892 cancelling the appointment of the petitioner will show that no reason whatsoever has been shown given. It appears that appointment given to the petitioner were cancelled without affording any opportunity and without giving any reason within. Therefore, this is a complete violation of principle of natural justice, and on the ground of non-traversing the statement made in lead petitioner, it must be deemed to be correct in accordance with law laid down in the Apex Code in nothing but case. In BOT matter, Annexa 3 series order cannot be stand, and accordingly, Annexa 3 series order terminating service of petitioner shall be stand first. The petitioner shall be reinstated in their service. Yes? It is made clear that if there was any irregularity in making appointment, an authority may take action after giving notice to the petitioner and pass necessary order in accordance with the law. But the petitioner shall be reinstated in service immediately within 1 month and from the date of receipt of this order, and salary or due shall be paid after their reinstatement according with law. This petition shall any dispose of. And petitioner therefore then file and review petition, that is also next 30. In that case also, that is also disposed as a disposal in Pakistan. And thereafter, the petitioner sent to the training, Lordship will find it Annex 32. They pass the basic training which is required to be done. Thereafter, 2007, their salary has been stopped. They oppose this honorable court. The honorable court direct to pay data, that is read petition number 1293, Lordship will find in Annex 5, page 33.
Okay. You also a petitioner here?
Yes, I'm also petitioner. Is my name is indicated in serial number 4. Here's the Then after hearing after long the judgment has been passed, Lordship judgment will start at on page 36. I'm slowly read this judgment because every line of this is very important. Distress by the petitioner on non-payment of their salary from the month of September, in spite of service rendered by them, the petitioner before this court for recognition thereof. I have heard the petitioner who came to a presently serving as an assistant teacher of various LP school of the state contended that they had been appointed as such following selection under the relevant rules. On the earlier occasion, in view of some undue and unexplained delay in release of salary, the opposed this which CR number 417, which was disposed on 12/2/1992,
with a direction to respondent authorities for payment thereof for the period for which they have serviced. It was thereafter that they were served with show cause notice, asking them to explain why their service is not terminated. This was on 33 to 1992. Though the petitioner responded to notices, were expecting for February response by order dated 18/5/92 issued by the Deputy Inspector of School Dhamaji, their service were terminated. And according to the petitioner, this action was apparently illegal, unfair, and unjust. They preferred appeal against the same director elementary education. They also opposed this court, court with CR number 61793, which I have already judgment giving. Challenging their termination. During the pendency of the aforesaid reports in their department appeal, which was initially heard by Deputy Inspector of School Dhamaji, who has dismissed. The petitioner then effected the amendment of the writ petition, incorporating salience of dismissal of the appeal, as well as CR 617 was eventually disposed of on 14/11/1995. Interfering with the order of termination of the petitioner service with a direction to state the respondent to restate them. The party has, however, granted to departmental authority to initiate the appropriate action if so advised, with due notice to them. Direction also is to release their salary following the reinstatement in service. According to petitioner, a review has been filed and thereafter by the state respondent, which was closed in first was. Their present grievances is that though since they have been rendering their services to the satisfaction of all concerned, suddenly since the month of September 2007, their salary has been withheld. It is their categorical stand that their salary till the month of August of 2007 has been paid without any demur. The Director of Elementary Education Assam responded to in the affidavit while admitting the institution of the CR 6193 and order passed therein above has contended in substance that petitioner were appointed without following the procedure of selection and appointment as enumerated by the relevant rules, executive instruction, and administrative act. It was therefore that notice of termination of service was issued. According to the deponent, the petitioner included in 178 teacher identified to have been inducted against non-existing post under the Dokuakhana subdivision in the Lakhimpur district. The answering respondent has maintained that their salary has been withheld in compulsory direction of the concerned department authority having regard to illegality and the appointment as identified. The affidavit, however, did not disclose as to what steps, if any, taken by the state husband after decision of the court in CR 61793 vis-a-vis petitioner before withholding their salary has urged that in face of the clear and unequivocal direction of the court contained in the judgment and order dated 14/11/1995 passed in CR 61793, the impugned action of withholding petitioner salary from the month of September 2000, though they are rendering their services without any break, partially arbitrary and discriminatory, and therefore a writ of manner ought to be issued to respond to release the currency and as well as area salary. Mr. Minister, submit that the non-ability of record, he is not in a position to dispute that the decision of court rendered as CR 98 does not govern the present petitioner. He, however, submit that there as the appointment prima facie illegal and that further probe into this issue is essential. And the decision without their salary cannot be altered with the law. Therefore, no relief is paid or to be granted. This is the submission. Again, they have reiterated in their affidavit. Present affidavit. I have bestowed anxious consideration to the rival pleadings and the argument advanced. The judgment and order dated 14/11/95 passed in CR 61793, which have a decisive bearing on education in hand, deserve to be referred at this stage. Operative portion is that in view of the matter Annexa 3 series, order cannot be stand accordingly Annexa 3 series order terminating the service of the petitioner can cost and shall be reinstated in their service. It is made clear that if there is any irregularity in making appointment, the authority may take action after giving due notice to the petitioner and pass necessary order in accordance with law. But petitioner shall be reinstated in service immediately within a period of 1 month from the date of receipt of this order. And the salary due to the petitioner shall be paid after this according with law. It is obvious from the above except the aforementioned decision, this court, while interfering the termination of the petitioner, directed the reinstatement of service and released their salary within 1 month thereof. The department authorities were, however, permitted to take appropriate action petitioner after giving due notice to them. This is no longer at the bar that above order has attained finality on date. Though Mr. disputed the claim of the petitioner's claim of being serviced as on date, in absence of any assertion to that effect, the state affidavit, the same cannot be entertained. This is more so in the face of the perceived averment of the petitioner that they continue to be in service as their resident. In terms of the above decision, this court has been receiving their salary till the month of 2007. The affidavit does not disclose either or allude herein above that respondent authority has served any notice on petitioner informing them any further action to be taken against them on the ground that their appointment has been against non-exist post, therefore illegal. The state respondent have not claimed either that petitioner has not put in the notice before the holding their salary from September 2007. In the above factual premises, there is no other alternative but to conclude this petitioner in terms of the direction content and in the order that of CR number 61793. If as on date they are rendering service to the department are entitled to their salary. In other words, if petitioner are in service, their salary and arrears from September 2007 is payable and ordered accordingly. As the Lana Council Department has appraised the court, the inquiry is in progress to identify illegal appointment in the subdivision involved. The names of the petitioner are enlisted among those of the illegal appointed. It is made it clear that if the completion investigation is underway, the appointment of the petitioner are found to be illegal, as claimed by the departmental authorities would be open to oppose this court appropriate modification of this order, as would be called for factions accompanied by the petition can dispose of it. And thereafter, they have challenged this petition on a review petition. That will find lordship will page 40. That was dismissed by the court. List the 43 is the judgment was started from the 40. A review of the review of the short by the state. I have heard is appearing for the review and people advocate for the opposite party. The opposite party representative had opposed this code with anything. That is a fact. It is a fact of the case is giving, taking the individual remedy and give the inspector service being rendered by the satisfy all concerned. Their salary since the month of September 2007 had been withheld. According to them, they are serving as assistant teacher in various LP schools of the state, having appointed in a selection under the relevant rules. In course of their service, they were on 3392 serving notice asking them to explain why they terminated. Though they replied thereto by order that and to issued by Deputy Specialist Dhamaji, service or terminated. Thereafter, they instituted CR 61793, asserting the action, this action. By the order that 14/11/95, this writ petition was eventually disposed of, and order of termination of the service were interfered with and direction was issued to the state respondent to the restated. Liberty was, however, granted to the department authority to initiate appropriate action if so advised. With the due notice of that. A direction of release of salary following the reinstatement in service was made. A review petition, though filed thereafter, state response and the same was closed. The Director of Elementary Education, Assam, implemented as the response number 2 in the writ proceeding in this affidavit, admitted the aforesaid order dated 14/11/1995, rendered in CR 617/1993. But they insisted that the opposite party petition had been appointed without following procedure of selection and envisaged by the Redmond Road executive instruction and administrative guidelines. He contended that they were included in the list of 178 of identified as a non-existing inducted against a non-existing division in Lakshmipur district. That the salary had been withheld in view of the illegal appointment or award. The court, by the judgment dated 1968, now sought to be reviewed after hearing the counsel of the parties on a consideration of pleading directed if the opposite party writ petitioner were in service as claimed by them, their salary in areas from certain was payable. In arriving this conclusion, the following factors were taken into note. Kindly note. By the judgment, an order dated 14/11/95 passed in CR number 61793, and the order of termination of their service had been quashed by direction and of their reinstatement. This decision had attained finality in absence of interference of any higher forum. The opposite party, writ petitioner, have purportedly averred that they are continuing in their service since their reinstatement and have received salary till the month of August 2007. There was no material on record suggest that departmental authority has served any fresh notice on them informing them that their further action on the ground of their appointment has been against them. The state petitioner have not claimed the opposite petitioner have put on notice of withholding the salary from 2007. The above are not investigating this court while issuing the direction of payment of salary opposite party writ petitioner from 2007 granted opportunity to state government to oppose it for appropriate modification of safeguard if on conclusion the inquiry was in progress or to identify illegal appointments in the subdivision involved. The opposite party writ petitioner were identified to be illegal appointed. Review applicant now seeks to contend that at the time of disposal of writ petitioner 1293/2008, the fact of PIL 67 petitioner pertaining to an investigation agent inquiry into issue of illegal appointment entirely in the Hemaj subdivision R12 Lakhimpur district was pending, and from the time to time division had been passing the order closely monitoring the had not been brought on record. According to them, they considered the gravity of the issue being pursued in the aforementioned public interest litigation, a step underway to unearth the process of large-scale misappropriation of public funds by way of release of salary in means of terminated discharge. This court, if not made aware of this development, might not have passed the order now. It's again referring in particular the series of orders passed in PI 67 and was sought to reinforce the above plea to contend that the judgment and order dated 19/6/2008 ought to be recalled. According to him, salary of the above of the writ petitioner has been withheld from the 19 passed in PI 67/2007. Mr. Vora, while dismissing the above plea, has submitted that as it apparent from the affidavit in opposition filed by the director of elementary 1290/2008, the factum of the pendency of the PI has been placed on record, and this was court has rendered decision were duly taking note thereof. According to him, otherwise none of the order passed in PI as such debarred payment of salary in deserving cases pending completion of the investigation. Upon hearing the learned counsel parties and on a consideration of ground urged on behalf of the applicant, this court is of opinion that no case of review for the present has been made out or matter of the order dated 19/6/2008 passed in the not only as submitted by the Burua, the Director of Education affidavit has mentioned the above the period order passed there and policy do not interdict payment of salary to the petitioner who had been in fact rendering their service that too, after the order of their termination had been interfered with by this court and with the consequent direction for his children. The amendment made in review petition revealed that inquiry mentioned in 60 is in progress and has not been completed. The public interest litigation is unpending. In above given matter, the consideration of above pleaded fact document on record. The reason recorded in the judgment that no review thereof aforesaid in the order have been rejected no. And this order have not been challenged in the higher forum, and this order is attained finality. Thereafter, they have not given payment. There is a contempt proceeding is going on after the court is become so burden on them, and thereafter they release their salary up to 2014. They have given in their, they have clearly given in their in affidavit This is my pleading on my case. Now, I take it out their affidavit. Their affidavit which I received on 5/4/24.
Lots of in our affidavit, you lots have to move forward. See from paragraph 5.
Slowly. You get your paper, son. I will sit down. I will not utter a single word when you argue. That is a procedural report. They have giving a details giving they in their affidavit they have not controverted anything which I have stated. They are giving a facts. They told they stated they stated their affidavit. Their screening committee. I'm reading the outline of given last day. The government have made a screening committee, and screening committee they did this making the three category of person, and they said that those who are having the requisite qualification, that is the passed in basic training, and the GPF, they should be regularized as a assistant teacher, and those who have not having the qualification of training or they will be appointed as a tutor, and that is happening. That in fact, their document says the screening committee advised them. Screening committee held on 2016 after my retirement. It said that if any ability is prepared, they should be put on notice. Their memorandum itself, I will show you. And the government said that I will not go to that extent. We know that those who are having qualification of training, they are giving the assistant teacher, and others are giving tutor. And they said that I could not be appointed as an assistant teacher or tutor because I am retired. Because I am retired, even though I am qualified for appointment, but matter is listed nonetheless. That is their stand. And also you will find the cabinet memorandum they have annexed here. And it's a page 62. They have annexed page 62. That is possible. Day and a lot.
Page.
No, that so much visible in my computer. I like to this. The type copy is not giving. Page 63. I want to just indicate page 63, one paragraph. In second paragraph, also will find it pertain to mention. Got it? It is pertinent to mention that in addition to 8470. In addition to 8470 teachers, Dhemaji or Lakhimpur, who already terminated for serving in 1992, along with 14 other teachers similar nature, hearing conducted of the Office Director of Elementary Education on the month of June 2016. Therefore, this cannot be said by us. I retired before that, 2016. Only two petitioners were after that. all the local district has found to be appointed illegally and non-existing post. That is same thing written in the writ petition. And what they said, screening committee, screening is not an authority, but screening said, having regard to the above appointment, second way, he is 74 similar teacher, all they are distinct, they make it distinct 4 categories. Appointment during the ban period, appointment by the school managing committee, appointment against a non-existence post, no record valid of valid appointment. They make it this type of, but they are not ascertain who is the which one. And next breakup, sir, and therefore they say those, if you want to take action, he put on notice to them. They should not be appointment or the violation existence. But what happened? The government do not want, and they have to also find. There's a policy decision of the government that they will not go for the notice of the transaction. They making a three category of person. One who are qualified, having qualified, they will be assistant teacher. But we are not concerned of that because we are already been retired. Cabinet decision at 20. Even if for a moment I said, even if I am not retired, if I am not committed, I will come as the list 1 because the qualification of list 1 is lots you find in last paragraph, it's page 63. Those who have drawn salary, 63 last paragraph.
Yes.
Those who have, find A, those who have salary at some point of time after they have received appointment, pass in basic training, or T condition has been given. Teacher having following, teacher have fulfilled the following drawal of salary, they have received appointment, qualified basic training, this which we are saying, and GPF account. This person will be, they will put at the assistant teacher. If I am not retired, then I will come to that. Even then, I have not got, I will get the retirement benefit.
Baba, we'll take up
But
matter
now,
today I have a meeting at 4 o'clock. We'll conclude the hearing today.
Oh.
We'll fix a date.
Let it in the part hard option.
But Mr. B.V. Barwal, the council for the petitioner, as well as Mr. B.N. Sharma, the Standing Council Elementary Education Department, and Mr. D. Bhattacharya, the Standing Council Accountant General, Assam. Part and part. When? Next year?
January. As lots is convenient.
For the hearing. Ninth.
Oh, all petitioners come together. All petitioners. Oblige.
Can you do it? Talukdar, Accountant General in item 25, 26, and yeah.
So on my prayer, this matter was listed today for hearing, my lord.
Yes. Unfortunately, it's just not reaching.
Can it be a list on either 7th or 9th, my lord, of January?
9th. 9th of January.
9th of January, my lord.
7th.
On request made by the parties. List the matter on. That is also just before the Bihu, no?
Yes. Then, my lord, 21st, my lord.
That's a better idea.
Yes, immediately after Bihu vacation. I'm obliged.
Yes.
Lordship, item 28, can it be taken up on 19th, Lordship? on 17th.
This month.
Yes, item 28. Petitioners are serving without any remuneration. So some urgency was there, Lordship.
Okay. Heard Mr.
NZ Chaudhary.
Chaudhary, London Council for Petitioner, Secretary. Also heard MSD Mishari, London Standing Council, Secretary Education. List the matter when?
19, Lordship, or 17, as per your convenience, Lordship. Next week.
17.
Of the Lordship.